Items for delivery of order. Item number 20, RSA 48 of 2025.
Dismissed. No substantial question of law involved.
Item number 21, RSA 90 of 2025.
Dismissed.
May I please, Your Lordship?
Well, in a pending RFA, the Lordship has already issued notice in the continuation petition. In the meantime, in the execution case, attachment order has been issued against the department. I have already filed a stay petition. I pray for listing of this, if possible, today.
When?
Today, if possible. Already you have filed this.
Because in the second half there is one reference.
That's true. That's true. If
Petition bench.
petition on 30. I'll give the mention number. Lordship, comment.
May I please, Your Lordship? I beg to mention for listing of transfer petition civil, my lord. On 14th of July, my lord, on a reopening. Deeply obliged.
May I please, Lordship? Lordship, and MSC appeal, Lordship. Your Lordship directed to list the matter in the second week of May, Lordship. That is not listed. I am praying for listing of the case immediately after petition. MSC highly obliged.
May I please, Lordship? I beg to mention item number 22 on the supplementary list. Kindly fix the matter after petition number.
Item number?
Item number 22 from the supplementary list.
Twenty-two.
22.
On the pair being made by Mr.
NP Dwara.
N.P. Dwara, learned counsel for the
Petition.
recessal is the matter after petition.
After.
May it please your lordship, I beg to mention 2 MC appeal for listing for hearing after vacation any day. Much obliged.
May I please, Lordship? I beg to mention item number 5 and 6, Lordship. Matters may kindly be listed after the vacation, Lordship.
5 and 6.
Lordship.
I am appearing for the petitioner in item number 6 and the respondent in item number 5. So we have some urgency in the matter. Can I pray for a fixed date? I will not have any objection if it is adjourned.
Okay.
Date may be fixed.
On 21st July.
21st.
Yes, agreed by learned advocates of both the parties. Recessal is the matter.
Interim,
Interim,
like we continue in item.
interim is there.
Interim.
Yeah, interim order passed in item number 5.
Lordship in 6.
6.
We are in the
Order passed
petition.
earlier in item number 6. I'll continue.
Deeply obliged.
Item for motion bail application. Item 1.
May I please, Your Lordship? Well, this is a regular bail application. Charge sheet case, my lord. Trial is going on, my lord. Now the present stage is the evidence instance, my lord. My lord, kindly call for the scan copy of the lower court reports, my lord. In connection with it, session case number 366 of 24 pending before the additional session judge Dhobri.
This is second application. This is second application.
No, my lord. First bail application, my lord. Before this one, my lord.
Third, Mr. Omar, learned counsel for the accused. And Mr. P. Portaker, learned additional counsel for the state respondent. This application under section 483 of the BNSS 2023 is prepared by the accused, namely Ramiza Bibi and Zahirul Haq alias Zahirul Hussain, who are languishing in Jalajot in connection with session case number 366 of 2024 under section 120B 302-34 IPC. Pending before the court of learned additional district judge Dhobri. Since 12/11/2024 for grant of bail. Having heard the submission of learned counsel for both the parties, it is provided that recessal call for the scanned copy of the record from the learned trial along with the case date. Please the matter after petition.
My lord, maybe date may be fixed, my lord.
On 18th July.
All actually.
For motion item 2.
May I please, Lordship? Lordship, this is the CRP petition, Lordship. brief fact is that, my lordship, respondent has filed a complaint case under section 138 of Negotiable Instrument Act, lordship, for payment of rupees 27 lakhs 87,000 from the petitioner, my lordship, and which was settled amicably, lordship, before Lokadal, lordship. And till that, petitioner has paid rupees 20 lakhs, lordship, and 7 lakhs is remaining to pay. And petitioner is ready and willing to pay, lordship. Lordship, what happened during that period, lordship? Petitioner parents, father and mother have died due to severe illness, lordship, and he has to pay an amount rupees more about 30 lakhs, lordship, for his parents' medical treatment, lordship. That's why he cannot pay the remaining 7 lakhs during the time, lordship. And on last date, lordship, 10/6/2027, 2025, lordship, the engaged counsel of the petitioner has wants to submit a petitioner for praying for some time before the learned civil judge Udalguri, lordship, but the learned trial court had not entertained the same, lordship, and passed the imprint order directing the attachment of the Mahindra Scorpio of the petitioner for attachment, lordship. That's the case, lordship. Lordship, we are ready to pay, lordship, but we need some time, lordship.
Are you aware of the recent decision of Supreme Court,
Lordship,
where it was directed that all execution proceedings shall be disposed of within a period of 6 months?
lordship. Lordship, on that stand, the imprint order has passed, lordship. We are regularly paid, lordship. We are regularly paid, but due to illness of my mother and father, and they had passed away, lordship. For I am suffering some financial crisis, lordship. And my parents has been bedridden for last 4 years, lordship. And amount is rupees 27 lakhs, lordship. Almost 20 lakhs has been paid by me, lordship. Only 7 lakhs is remaining to pay, which I will pay, lordship. But only fact is that I did some time, lordship. But
When the execution case was filed in the
execution,
year 2022,
lordship. When
till today, how many years elapsed?
lordship, 3 years.
3 years.
3 years, lordship.
And the Supreme Court has fixed the timeline as 6 months.
6 months, lordship.
What the trial court will do, tell me.
Lordship,
What this court will do.
on that period, I have paid rupees 20 lakhs, lordship. But the fact is that my parents is ill. They have been bedridden for last 4 years, lordship.
Go to the Supreme Court then.
Lordship, just allow me some time, lordship. I will pay only 7 lakhs.
How can they
remaining,
allow
lordship.
you time? Tell me.
Lordship, I am regularly paying, lordship, as per direction of the trial court, lordship.
If I allow this petition, then I have to disobey the order of the Supreme Court.
Lordship, there is a fact that my parents has been bedridden for last 4 years, lordship, and I have been go through a financial hardship, lordship. Lordship, I am paying regularly, lordship. Rupees 20 lakhs already paid, lordship.
But Mr. M. What is your name?
Ahmed Soika, lordship.
M.S. Soikia, learned counsel for the petitioner. In this petition, under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure. The petitioner has challenged the order dated 10/6/2025 passed by the learned trial court,
Civil judge,
executing court in money execution case number 2 of 2022. By the learned civil judge senior division Udalguri. It is to be noted here that by the impugned order dated so and so, the learned executing court person to the order number 18 dated 25/3/2025 issued by this court has dismissed the petition filed by the petitioner for allowing him some time to make payment of the decretal amount, and thereafter directed the degree holder to take necessary steps for the attachment of the vehicle, Mahindra Scorpio vehicle belonging to the degree holder. No, sorry, belonging to the judgment debtor, the present petitioner. Present petitioner. Mr. Soikia, learned counsel for the petitioner, submits that the petitioner could not make payment to the entire amount on account of illness of his parents. And his both of whom already suffered demise. Then he needs some time to make payment to the aforesaid amount. Aforesaid amount. And therefore, it is contented to allow this petition. But having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record and also perused the impugn order dated 10/6/2025. It appears that the title execution case number 2 of 2022 was registered in the year 2022. And till date, 3 years already elapsed. It is also to be noted here that Honorable Supreme Court in the case of Pariamal, which indicated death through LRS and others versus E. Rajamani and another, etc. In SLP, which indicates C number 8490-8492 of 2020 has fixed the timeline for completion of the execution proceeding as 6 months. 6 months. In view of above, the impugn order appears to be in view of above, the impugn order cannot be said to be suffered from any illegality or impropriety requiring any interference of this court. Accordingly, this petition is dismissed.
My lord, I need only 2 or 3 months, my lord. I'll pay, my lord.
You go and file application before the trial.
My lord.
Obliged, my lord.
Item number 3.
May I, Lordship. My lord, this is an application under section 115 of CPC against the order which was passed by the trial court against my application on order 21 rule 97. My lord, what happened in this case, a decree was passed ex parte against some of the heirs of Gunaram Das. And in the case, my lord, I was not impleaded, although I had the right in the property, but I have not been impleaded. So when the decree was put in execution, then I filed the application order 21 rule 97. That as per the CPC, my lord, I have got the right to file that application, order 21 rule 97. And there is a bar also in section rule 101. I cannot go direct to the court to file a suit against that. Simply, I have to file this order 21 rule 97. Accordingly, I filed this application, and that application is to be registered like a suit, my lord. Everything is to be decided like a trial of a suit. This should be decided in the suit. But the trial court has decided, my lord, will find the impugn order at page 103. Trial court has decided without framing any issue, and the trial court has decided simply on the basis of one document, that is Vibhagnama. And by stating that the Vibhagnama was not registered. So the right cannot be claimed on the basis of that Vibhagnama. And my lord, so far the law is concerned, Vibhagnama need not require to be registered, my lord. The Supreme Court judgments are there. Vibhagnama, which doesn't create any right, my lord. It is an arrangement between the co-owners to reside a particular space in the property. That some owner will reside in that part of the property, some owner will reside in that another part of the property. So it is not required to be registered. So 76 Supreme Court and then other Supreme Court judgments are also there. My lord, I am reading the relevant portion of the judgment, my lord will find.
When the next that is fixed?
No, my lord, my petition was rejected. So against that, this 115 is attested only. Thus, it is like an appeal, my lord, because appeal has not been provided. The provision is
No,
115.
my question is when the next that is fixed.
Next date is, this petition is disposed of, and next date is fixed for execution, my lord. The decree will be executed.
Yes, I am asking you the date of that proceeding, execution proceeding.
Yes. Execution date, my lord, he cannot say, but
Not say, we will issue notice that this is this.
But at the same, my lord, the decree should be suspended, my lord, the operation of the decree, my lord. Otherwise, the decree put in execution, I will be thrown out, the property, my lord.
Maybe thereafter also you have remedy.
My lord,
Heard Mr. Your good name, please.
J. Sharma.
Jay Sharma, learned counsel for the petitioner. This petition under section 115 of the Code of Civil Procedure is preferred by the petitioner, namely Orun Das, challenging the order dated 5/6/2025 passed in Nizia case number 33 of 2022, arising out of title execution case number 1 of 2022, filed by Srimati Soyanika, the passed by the learned civil judge, Junior Division Bozali at Patla. Peruse the petition and the documents classed in record, and also peruse the impugned order dated 5/6/2025. Issue notice to the respondent returnable in 4 weeks. Have been taken by registered force with AD and also by usual process with from the list of the 4 weeks.
My lord, the degree should be stayed, my lord, otherwise my lord, it will be,
You cannot say the date also when the next date is fixed.
date, my lord, you will find it out the date in
If
the
there is, if any urgency arises, then you can mention the matter, we will take it up.
urgency, my lord, in the month of July, but exact date I cannot say.
We'll say,
Because
you may
in-
mention the matter. If
My lord,
any such
if
urgency
the
arises,
decree is not stayed, my lord, my every right will go out, my lord. I will be out of position, my lord.
no stay.
Item number 4,
My lord, if the stay decree is not stayed, my lord, there
Sorry.
will no remedy. And
Sorry.
that my lord may kindly look at this section, rule 101, my lord.
Sorry. Yes, next item.
item 4.
In this case, the petitioner initially had filed a case under section 12 of the Domestic Violation Act, along with the mother and the brother. But since he became the matured, so no order was passed in their favor. So ultimately, she filed an application under the section 23 of the Hindu Adoption and Maintenance Act. And the learned trial court, district judge, by order at 6/6/2017, granted certain monetary relief to the tune of rupees 33 lakhs and odd. My lord, this order was challenged by the father, who is the OP number 1 here, in the revision petition as well as before the Supreme Court. So all those petitions were dismissed. Thereafter, learned district judge on 18/1/2023 passed an order, directing the respondent number 1 to deposit the decretal amount. Lordship will find that page.
What is the amount?
Is 33,75,000 on different heads, my lord. The order, your lordship will find, my lord, at page 19. And relevant will be at page 28. Last portion, my lord. The respondent, Dr. Deepak Kumar Gupta, is directed to pay rupees 5 lakhs as interim relief from the period between 8/7/2013 up to 10/5/16. Dr. Deepak Gupta is directed to 5 lakhs towards the expenses of Shivangi marriage ceremony. Respondent Deepak Kumar Gupta is directed to 25,000 per month as maintenance to Srimati Shivangi Gogoi from the date of this order. So while computing all this amount, it comes to about 33 lakhs and 75 rupees. We have also filed an execution case for this. So therefore, the trial court on 18/1/2023 at page 33.
At what is this, the money execution case is pending?
My lord.
At what is this, the money execution case is pending?
My lord, in fact, what happened, my lord, we filed two different petitions, my lord, on 5/6/2024. And again on, my lord, 1/2/2024. My lord, these two petitions were filed, you also will find, my lord, page 76.
No, Mr. Soikia, I am asking you, that what is this that proceeding is pending?
Here, the opposite party is not appearing in the execution case. Now, so far as the recovery of the amount or attachment of the amount, etc. The Oil India was directed to furnish the amount that has come to due to the him. And accordingly, they have also furnished having sufficient amount, but on different heads like Provident Fund, gratuity, etc. And leave encashment, etc. So we have filed a petition on 5/6/2024. Now the court has, the trial court has rejected that, saying that this is barred under section 61G of the CPC, that it is constituted to be a debt, so therefore it cannot be attached. Then we have filed another petition on 18/12/2024 to hold the decretal amount, direction to the Oil India Limited to hold the decretal amount till the execution is completed. That also has been rejected, saying that as by earlier order dated 5/6/2024, it has been rejected, so it is in the same line, so that again has been rejected. So against these two order, I have come here. Firstly, this particular the relief granted, it is not a debt, as appearing in the section 61G. And rather, it flows from Article 15(3) as well as Article 39 of the Constitution of India. The various high courts have also already held this is not a debt, nor the decree holder is a creditor. This is a legal obligation of the father or the husband to maintain the wife or the children. So therefore, this does not fall within the meaning of this debt, nor the applicant is a creditor. And in fact, what happened, so far as the maintenance case is concerned, though that was also an ex parte order, he has prepared an application for change of his bank account. There we have, the mother has intervened in the that petition, and this court, after considering, directed the Oil India Limited to satisfy the decree and then only release the amount to the bank account that was given by the respondent number 1, and accordingly that amount has been that decree has been satisfied. So that amount was also out of the Provident Fund. There, the respondent number 1 did not objected to it. So even if some legal rights have there, that also has been waived. So that all these things have not been considered by the trial court. Almost mechanically, on the basis of the this provision of section 61G, has rejected it. It's of 2006 or 2007.
Yes, you are for respondent.
Is Oil India.
I know for
Oil
Oil India.
India.
I have an interim prayer, for a direction to the Oil India to hold that amount so that it does not remitted to the account of the respondent number 1. That is my limited prayer, only to hold it, my lord.
But Lordship, these are the retirement dues, Lordship. Retirement dues of the respondent number 1, Lordship. What happened, Lordship? The respondent 1, pursuant to a department proceeding, he was dismissed, Lordship. He has challenged this order before this honorable court, and ultimately honorable court, Lordship, page 28, ultimately that dismissal was set aside, Lordship, and thereby directed the respondents to release his retirement dues, Lordship. And now the said respondent 1 has already filed a contempt petition also against the Oil India Limited. Page, Lordship, 36. Start from page 36.
Page number?
Page 36. It start from page 36, Lordship.
Yes.
Operative part, Lordship. Now, Lordship, kindly come to page 57. Paragraph 26, Lordship.
Yes.
Thus, this court is the unhesitant view that the authority has committed serious procedural error by not framing specific charge and making conclusion on the basis of the facts which were not part of the statement of imputation, resulting in manifest injustice and violation of principle of natural justice, inasmuch as the petitioner was not aware of the specific allegation to defend himself, as discussed and detailed herein above. This court is also unhesitant view that the charges against the petitioner was concluded to be proved on the basis of the evidence as discussed herein above, acting upon which a reasonable person acting reasonably and with objectively could not concluded in that way. Thus, the petitioner did not receive fair treatment during a disciplinary proceeding. Similarly, the explanation given by the alleged unauthorized absence and for not joining within time or even not taking into consideration, and no conclusion was made as regard the willful disobedience absence in duty. In view of the above determination of the decision, this court is of the view that petitioner has been able to make out a case of interference in exercise of power of judicial review. According to the impugn order dated 16/9/2014 and 23/1/2020 stands set aside and clause. Having held so, this court cannot also be obvious the fact that petitioner has in the meantime attained the age of superannuation. Therefore, in the given facts of the present case, it is provided the petitioner be treated to continue in service till his age of superannuation for the purpose of granting him the superannuation benefit, and his pay and other benefits be nationally fixed for grant of superannuation benefit. After such fixation, the benefits be granted, if any, to the petitioner. Such exercise will be carried out within a period of 6 weeks from the date of receipt of the certified copy of this order to be furnished by the petitioner before the competent authority. As regard the claim of back wages, the initial burden is upon to the employee to establish that he was not gainfully employed during the period of dismissal. It is also well stated that a right will not be created for grant of back wages only for the reason of setting aside an order of dismissal by a court, and the same will depend upon even of his case. In the case in the hand, the petitioner was by profession a doctor, and whether he was gainfully employed during the period of dismissal or not cannot be determined in the present proceeding. However, it is provided that in the event the petitioner claims back wages before the authority, the respondent employer shall consider the same and pass a reason order in this regard. Such exercise be carried out within a period of 6 weeks from the receipt of the claim that may be filed by the petitioner. Now, as per the paragraph, Lordship, the statement made in the requisition, Lordship, paragraph 6, Lordship,
Six of the?
this here, Lordship, paragraph 6, Lordship, page 7. The respondent number 1 has already released sum of rupees 32,20,000 to the mother of the petitioner, Lordship, out of the retirement dues. That the petitioner states the respondent 1 approached the honorable court by filing charge of praying among other for direction to the respondent 2 authorities to deposit credit all the dues of the respondent 1 payable to him in the saving bank account of the respondent 1 maintained at HDFC Bank, Duliazamba. This honorable court, after hearing the parties by judgment notice, so dispose of the said petition with observation to transfer the amount to the account of the choice of the respondent 1, subject to compliance of the order that is so and so, passed by the judicial magistrate first class Dibrugarh in share case number so. Pursuant to the final order dated 6/10/2000 passed in so and so, the respondent 2 paid to mother of the petitioner a sum of rupees 32,20,000 on 5/6/2024 by deducting from the accumulated PF dues of rupees 87,98,358, Lordship. Now, the impugn order, Lordship, was passed on 5/6/2024. As these dues are the retirement dues, Lordship.
Dues are?
Retirement dues of the respondent 1, Lordship. That's why the honorable court, Lordship, can peruse the page 77 of the impugn order. This is order dated 5/6/2024, Lordship. Today was fixed for hearing of the petition number so and so filed by Srimati Tulika Gugoi, mother of the decree holder, Srimati Shivangi Gugoi, praying for directing oil Duliazam to satisfy the decretal amount due to the decree holder of rupees 30,75,000 by deducting the same from the benefits dues of the judgment debtor and pay to the decree holder of the sum of rupees 30,75,000 in satisfaction of the decree in this instant money execution case. Kindly come to paragraph 5, Lordship. heard the learned counsel for the decree holder as well as the peruse the record of the documents submitted by decree holder and carefully peruse the provision of CPC in conducting a money execution case. After going through the section 60 of CPC, read with order 21, rule 30 of the CPC, I find that this petition is not maintainable as the or under section 61G of the CPC, stipends of gratuity amount to the pensioners of the government or local authorities or of any other employer or payable out of the any service family pension fund notified in the official gazette by the central government or the state government in this behalf and political person belonging to the judgment debtor are barred from the attachment order so and so. Consider above facts and reasons, I find this petition is not maintainable and hence dismissed. The person to do that they have not challenged this. Now thereafter again file and petition lordship and which was also rejected. That is case 88 lordship. Case 87 order. Since earlier order was already rejected, lordship, earlier petition was already rejected. Now both the impugned order has been challenged.
So, Mrs. Soika, you show me the provision under which the court can attach the retirement and pensionary benefit of the.
And regarding
Yes, my lord.
back to this,
What do you do? My lord?
Show me the provision
Lord.
under which court can attach the retirement benefit of the respondent.
Lordship, this of the section 61G has been interpreted by various high courts. My lord. And to content, my lord, there 61G, your lordship will file stipend and gratuities allowed to pensioners of the government or of the local authority or of any other employee or payable out of any service manager fund notified in the official gazette by central government, state government, and the political person. My lord, this has been interpreted to be not a debt by the various high courts, my lord. I'll just place one of the judgment, my lord. Kerala position. Because it is a legal obligation of the husband. It is not a debt. Someone has taken loan or someone has borrowed some money. So there is a legal, the debt and the debtor and the creditor concept comes, my lord. This is an obligation, my lord, that has flown from my lord Article 15.3 as well as my lord 49, my lord. This Kerala judgment, my lord, take a lordship to paragraph 41. Abdul Sattar, my lord.
Paragraph number?
Paragraph number 41.
Yes.
In the light of the definition of the word creditor and that payment of alimony is not a debt or a liability and that it is not one founded on a contract express or implied, but it is a legal means of enforcement of the obligation of the husband and father to maintain his wife and children. We hold that the respondent number 2 and 3 cannot be branded or labeled as creditor of the petitioner. The liability of the petitioner to maintain his children is statutory, sacrosanct, failing within the sweep of Article 15.3 and Article 39 of the Constitution of India, as observed by so and so. The Parliament in its 42, the Parliament in its wisdom to protect the neglected and improvised women and children has enacted several legislation, both personal and uniform, applicable to all cross sections of the society, making it mandatory of a man to maintain his wife and children to alleviate destitution. If wives and children are treated as creditor falling under exception to Rule 124 of the rules, it will render laws relating to payment of maintenance redundant. Such a suppressive interpretation cannot be permitted. Then lordship may come to paragraph 46. In view of the above finding, the law declared in the above authority pronouncement, we have no doubt in our mind that the respondent number 2 and 3 are not the creditor of the petitioner falling within the sweep of Rule 124. Petitioner cannot defeat his children from realizing maintenance from him, which is their indefeasible right having precedent over the exemption under Rule 124. This court cannot remain a mute spectator or to the agonizing delay that has occurred and the civilian method adopted by the petitioner to thwart the execution proceeding. Therefore, we reject the petitioner's contention. Then 49.
Mr. Soika, you see here there is a decree, money decree.
Lordship, that section 61G also, my lord, interpreted in paragraph 49. In addition to our finding with reference to Rule 124 Kerala Service Rule Part 3, we find that the legislature has knowingly included the word family pension fund in Section 61G of the code. Therefore, it has been held that wife and children do not fall within the fold of exemption to Section 61 of the code, as family pension fund is payable to the family dependents of the petitioner as exempted from attachment only of a person falling outside the purview of the family. The above provision is almost analogous to Rule 124 of the Kerala Service Rule Part 3. Our finding on Rule 124 is equally applicable to Section 61G of the code. So there is no longer bar of the respondent to attach stipend and gratuity of the petitioner. Then again, my lord, in another judgment of recent 2022 of the Madras High Court, P. Amutha, in paragraph 7, the question, my lord, that was made out. Now the issue for consideration. Paragraph 7.
Yes.
Now the issue for consideration is whether the maintenance allowances granted to the wife can be attached in view of the bar under Section 61G of Civil Procedure Code and Section 11 of the Pension Act 1871. This section 11 of the Pension Act has been quoted, my lord, at page 7. Then let's may come to paragraph 15. The concerns of the social justice, the
Yes.
paragraph 15. The concerns of the social justice, the cornerstone of our constitution, will be protected. Therefore, I hold that the maintenance allowances granted to wife cannot be considered as a debt and she is not a creditor. Hence, exemption under Section 11 of Pension Act as well as exemption provided in Section 61G of the Penal Code cannot be granted to a husband. Hence, the order passed by the Honorable Judicial Committee is unsustainable and is liable to be set aside. Now, here another aspect of the matter, my lord. Though he has shown the order against the termination that was challenged, there's another writ petition filed by him for change of his bank account, where we have intervened. My mother has intervened in respect of her decree under the Domestic Violation Act. That order, your lordship will find page 16.
Yes.
And that's a long method. I'll just take your lordship to paragraph, page 67. So, counsel representing the respondent number 6, that is the mother who was entitled to 30 lakhs and out. Copies that opines that the respondent wife was granted relief under law, more particularly under the DB Act by a competent court, and as such order has in the meantime attained finality. However, for the interim order passed by this court, the respondent has been deprived of the benefit of the order passed by the competent court, and therefore a direction may be issued to the respondent to act as per direction of the learned Judicial Magistrate First Class Dibrugarh. There is no iota of doubt that the petitioner shall have a right to get his legal dues transferred to bank account of his choice. However, when the same is a salary account, the transaction shall be subject to prescribed norms and in this regard set by the employer and bank. In the case in hand, the respondent employer has taken a stand that the employer is not having any difficulty in transferring the dues in the bank account of choice of the petitioner. That being positioned, no dispute remains to be adjudicated in this regard. However, this court cannot be oblivious of the direction issued by the learned Judicial Magistrate First Class Dibrugarh in CR case number so and so, as discussed and quoted here in above, in as much as the respondent Oil India Limited shall be under bounden legal duty to honor such judicial direction subject to any further order that may be have been passed by the Revisional Appellate Court. In view of the aforesaid, more particularly in view of the stand taken by the respondent Oil India Limited that they are ready to transfer the amount to the account of choice of the petitioner subject to compliance of the order of the London Magistrate dated 3/11/2014 passed in CR case number 510/2014. Nothing survives to be executed in the present writ petition, in as much as the court in the present writ petition proceeding neither can comment nor can determine the legality and or validity of the order dated so and so. So therefore, this amount has been they have deducted the amount from there and it has been transmitted to the mother's account, which he has also read. So that was out of the Provident Fund account. The respondent number one, this writ petition was filed by the respondent number one. Oil also was present. They said they don't have any objection with regard to transferring the amount to the new account. But there is an order of the judicial magistrate regarding satisfaction of the decree. So the court says it is an obligation of the oil to honor the order of the learned judicial magistrate. And accordingly, this order has been passed and thereafter the amount has been deducted, paid to the mother. Now here, my lord, the oil, I don't know whether he is objecting to it or I do not know, but then, my lord, there it was, they said there was an obligation for them. But here in our case, as because the petition has been rejected, so therefore no direction could be, my lord, gone from the, my lord, judicial magistrate, my lord. And the respondent number one having, my lord, waived his right to object that this provident fund amount which sought to be deducted from my from the amount accumulated with the oil is a part of the provident account, so it is hit by section 60G. So that right of the respondent number one has waived. He has accepted this judgment. No further litigation has been done, and accordingly, amount has been.
Let notice go at this instance.
My lord, my only prayer, my lord, the amount is lying with entire amount. Lordship will kindly see the they have submitted a list.
Therefore, the question is whether court can attach that amount of money.
My lord,
Whether and under what provision the court can attach that amount of money.
my lord, this section 60, my lord, 61G does not come under way because it is not a debt or the creditor so as to, my lord,
That
was-
has to be decided only after hearing both.
Lordship, my lord, that is there. My lord, what,
Only after hearing you.
yes, my lord, what I am on, my lord, they have submitted an application. Your lordship will find, my lord, pursuant to the court's order at page 93.
Okay, your good name, please.
K. Kolita, Lordship.
You
Please.
inform the Oil India Limited not to release the amount, but we will not pass any written
Yes, my
order.
lord, only to keep on hold.
Lordship may kindly peruse the paragraph 12 of page 191. Already
before the-
one direction is there, Lordship.
Yes, I say
Yes.
because my petition has been rejected, so therefore, had there been a my lord, direction from the court, there would not have been any problem for them to my lord, release the
Paragraph 12,
amount.
already one direction is against oil, Lordship.
That is in respect of the decree in the divorce in the DV Act filed by the mother. This is under the, my lord, Hindu Adoption and Maintenance Act. Two different, my lord. Amount is also different.
Shivangi Gugoi, this petition filed by Shivangi Gugoi.
Hmm.
Same petition, Lordship.
Same petition.
Same petition, Lordship. Is
And by the application, my lord, at page 93, the
93.
oil has disclosed how much
Let
amount. is
notice
there.
go at this instance.
Lordship.
Heard, Mr. PJ Soikia, learned senior counsel assisted by Mr. PK Gupta, learned counsel for the petitioner, and Mr. Polita for the respondent number 2. Respondent number 2, Oil India Limited. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the order dated 5/6/2024 passed by the learned district judge Dibugar in money execution case number 1 of 2018. It is to be noted here that by the impugned order dated so the learned district judge Dibugar has rejected the petition number 1792 of 2024 filed by the petitioner for issuing direction to the Oil India Limited Duliajan to satisfy the decree by deducting the amount from the benefit dues of the judgment date. First, the petition and the documents placed on record, and also first the impugned order dated 5/6/2024, and also the order dated 5/2/2025.
Thereby rejected the petition number 5789 of 24. By the order dated 5/2/25. Two petitions we have filed. One is 1792/24, that is rejected by 5/6/2024. Then, my lord, this 5789/24, that is rejected by order.
Mr. Soikia, I am dictating the order. Please don't disturb.
I'm sorry.
And also the order dated 5/2/2025 passed in money execution case number 1 of 2018, by which the learned decisions Dibugar has dismissed the petition number 656 of 2025. filed by the present petitioner. Peruse the petition and the documents placed on record and also peruse the impugned order dated 5/6/5 of 2024 and also the order dated 5/2/2025. That notice be issued to the respondents returnable in 4 weeks. Step be taken on respondent number 1 by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 2 since Mr. Kolita entered appearance and received notice. However, extra requisite copy of the petition will furnished to him during the course of the day. Interim period of the petitioner will be considered on the appearance of the other side on next day. List of the-
This is an innocuous order I'm praying for. The amount is lying with the Oil India. If
No,
this,
I'm asking him not to release the amount till next day. But not in written form, verbally, I am asking.
the only thing is that if it is on record, then they'll be bound by to do that. And otherwise, my entire
You ensure that the amount is not released till next day.
Item 23.
Wait, please, Lord. Well, what happened here, my lord, the petitioner before your lordship filed an application under Order 21, Rule 97. My lord, the grounds which has been taken is that the decree holder sought a declaration of right title interest over a land where a school is established in 1957. Now, the land, my lord, the petitioners are a co-pattadar of that land. They were never made a party and they have gotten decree of exclusive right title interest over the entire land wherein the school was established, wherein the petitioner's land are also involved. Now, this application was filed. Thereafter, an objection was filed by the decree holders. They have denied our right. Now, the order which has been passed by the learned executing courts, your lordship will kindly find at page 78. My application was not entertained, saying that there is no cause of action as the petitioner has not been disposed. And 97, it has to be disposed. Can be filed only after disposition. Page 78, my lord of kindness.
Yes.
My lord would kindly see from third paragraph. In this connection, Order 21, Rule 99 has laid down that where any other person other than the debtor is disposes of the immovable property by the holder of a decree, the possession of such immovable property or such property as has been sold in execution of a decree by the purchaser thereof, he may make an application to the court complaining of such possession. So far as 99 of the application must be disposed from his their land in execution by the decree holder. In the instant case, the application filed this case for possible disposition of their land. So to speak, no disposition is done the applicants, so they are not entitled to submit any application for threatening disposition. It is a settled law that the rules come with a play when a third party is disposed and he has no cause of action unless he is disposed. A third party even cannot invoke Order 21, Rule 97 in anticipation of being disposed. Well, this proposition is absolutely contrary to the law laid down by the Honorable Supreme Court in Brahmadev and thereafter in Ved Prakash. May I just point out this? My lord will find fifth page, my lord. Paragraph 4. Start from a conjoined reading of Order 21, Rule 97 and 99. My lord finds. A conjoined reading of Order 21, Rule 97, 98 and 99 and 101 projects the following picture. If a decree holder is resisted or obstructed in execution of a decree for possession, with the result that the decree for possession could not be executed in the normal manner by obtaining warrant of possession or under Order 31, Rule 35, then the decree holder has to move an application under Order 21, Rule 97 for removal of such obstruction. And after hearing the decree holder and the obstruction is the court can pass appropriate orders after adjudication after controversy between the parties as enjoined under Order 21, Rule 97, Sub Rule 2 read with Rule 98. It is obvious that after such adjudication, if it is found that the registration obstruction was occasioned without just cause by the judgment debtor or by some other person at his instigation or on his behalf, then such obstruction or resistance would be removed as per order dated 2198, and decree holder would be permitted to put into position. Even in such eventuality, an order would be treated as a decree under 101, and no separate suit would lie. Such order meaning thereby only remedy would to prefer an appeal before the appropriate appellate court against such deemed decree. If for any reason, a stranger to the decree is already disposed of the suit property relating to which he claims any right, title, interest before his getting any opportunity to resist obstruction on spot on account of his absence from the place or for any other valid reason, then his remedy would lie in filing an application under 99, claiming that his disposition was illegal, that the possession deserves to be restored him. If such an application is allowed after adjudication, then as enjoined under 91 subrule 1, the executing court can direct the stranger applicant under order 21 rule 98 to put into position, or if application is found to be substantial, it has to be dismissed. Such an order by the executing court disposing the application one way or the other under order 21 rule 98 would be deemed to be a decree as laid down under 21 rule 103 and would be applicable before the appropriate appellate forum, but no separate suit would lie against such order as clearly enjoined under order 21 rule 101. In short, my lord,
Mr. Kaushik,
my lord.
there is also another decision of Supreme Court reported in 2024 SCC online SC 2821.
Is it Bet Kumari, my lord? This was again followed in Bet Kumari in 2023.
No, in Ranjit Kerry versus Shiva.
My lord. Here, my lord, also it has been said, once an application is filed, my lord, it cannot be that.
No, in that case, Supreme Court has held that there must be disposition.
That
You go through the judgment and
can it be after some time, my lord? And just
yes, second half.
second. Very well. Thank you. Grateful, my lord.
24.
May I please your lordship, can the matter, when we pass over for the time being?
25.
May it please your lordship. One of the order impugned is to be found at 178. There was a suit filed which came to be dismissed. And then the sisters of the original plaintiff, because the legal heirs didn't pursue, therefore the suit was originally dismissed. Your lordship will find that at page 99. That was dismissed because the original plaintiff's legal heir, the wife and the daughter, didn't choose to pursue the matter. I am the sister, we are the sisters of the original plaintiff. There was a counterclaim by the respondent. As we got to know about it, we filed an application under Order 9, Rule 9, along with a delay condemnation of 267 days. And that, my lords, the matter was being pursued from 2019. 2024, the engaged lawyer withdrew their wakalatnama. And then, if your lordship just have a look at page 178. This is the order impugned. Opposite party defendant 2 is represented, petitioner is absent without step. Upon hearing the and seducer, it appears that the learned counsel for the petitioner has withdrawn his wakalatnama in the instant case by serving retirement notice upon the petitioner, which was duly received by the petitioner 1, 2, and 4. The petitioner number 3 is the sister of petitioner number 2. In the instant case, under section 5 of the Limitation Act has been filed by the petitioner with a prayer for condemnation of delay of 267 days in filing the petition to set aside the order dated so-and-so and restore the suit, main suit. As the petitioner has failed to proceed with the case, instant case is dismissed for default. Then if your lordship turns the page, consequentially, this is the delay application was dismissed by this order. On the next page, your lordship would find towards the foot of the page, 6/11/24, in view of the order dated 6/11, in Miss J case number 76, that is the delay condemnation, wherein the Miss J was dismissed due to default. The instant case, that is the suit, was also dismissed. Then if you turns the page, then other cases implement were dismissed. But my lords, the counterclaim was, if your lordship now have a look at page 182, 611, in the middle, my lord. In view of the order dated 6/1 so and so in this case, the instant, because originally the suit was kept in abeyance. If your lordship sees the upper part, 19/7/23, plaintiff and defendant 1, 2, and 8 are represented. Proceeding of the instant suit are kept in abeyance till disposal of Miss J case number 70619 and so on. So these are the condemnation and order. But in view of the dismissal of those delay condemnation, if your lordship sees at page 182, 6/11/24, in view of the order dated 6/1/24, passed in which case number so and so, is instant case shall proceed. Fix so and so for ex parte argument on counterclaim. So the counterclaim was to proceed ex parte. And if your lordship sees at page 185, 3/5/2025, ex parte judgment heard, 4/6 for judgment. Then we moved an application before the trial court, that is, your lordship will find at page 187, whereupon the learned civil judge was kind enough to postpone the pronouncement of the judgment. If your lordship just have a look at 190. 4/6/2025, CC represent, today is fixed for passing judgment. However, prior to such pronouncement of judgment, the plaintiff filed so and so praying for deferment of pronouncement of judgment. Today at 10:30, the petitioner so and so and so and so praying for deferment of judgment today as they intend to file a CRP against the order dated 6/11. Service copy of the said petition is filed along with the petition. Let both sides be heard on such petition. First, as of now, the pronouncement of judgment is kept on hold. Fixed 1/7/2025 for hearing on petitions. My lords, I must fairly say, my lord, as we were examining the matter, this has been preferred under civil revision petition IO, that is interlocutory order. But there is a Supreme Court judgment as well we were looking against orders which is impugned as 178 because the delay condemnation was dismissed and then consequentially the application under order 9, rule 9 came to be dismissed. Against that, under order 43C, a first appeal against order is available. And the Supreme Court has held that civil revision may not lie. And so, my lords, but so as per law, I think I must fairly state, my lord, instead of a civil revision, because these are not interlocutory orders. These are first appeal against order. This was similar case. This was delay application against an ex parte judgment. So it was order 913. In our case, it is 99. So the High Court said civil revision is maintainable. But Supreme Court said that when there is a provision available under 41D, therefore, my only predicament is this, my lord, at page 200.
Problem is that 2 days back, we have dismissed one civil revision petition by holding that only the appeal will be maintained.
That is why I am pointing. This is the law as Supreme Court has held. This is proper. My only difficulty is that on 1st of July, that is, my lords, just 2 days they are fixed for. I want some limit. We'll file a first appeal. I have advised them because first appeal against order is the proper remedy. But it should not become infructuous. It is the civil judge was kind enough to hold and defer the judgment till 1st of July 25. Your lordship, just have a look at 190. Some protection till we file the first appeal against order. If the judgment is pronounced.
No, better, you can do one thing. You withdraw this petition, you file an appeal.
That we
raise vacation bench on 30th.
Lord is right. On 30th, your lordship
Yes.
is there.
Yes.
Would your lordship just by any chance we miss the bus? My statement, because in a withdrawal application, I know your lordships can't pass any. that we'll make a request before the civil judge 3 for deferring the pronouncement.
You can.
That if your lordship just records my statement or some, then it'll be easier for us to make a request for adjournment before the civil judge. We just need some protection till the first appeal is comes about for hearing. I don't know how your lordship will protect us, but this is the situation, my lord. Your lordship is absolutely right. The proper remedy is 41(3) is the first appeal against order. But before that appeal comes about, we don't want a situation that my petition for deferment is rejected and the judgment is pronounced in the counterclaim. Page 190.
Apart from this judgment, there is a judgment of 4 judgments
My lord.
and also of 3 judgments.
My lord. This seems to, because there is
And
direct
there is a
provision.
decision of full court of Kerala High Court.
My lord.
on
And this is Supreme Court has now laid down the law, so I can't argue on that. Only thing, if somehow this 1st of July is the only problem that we are facing. Lordship, we'll try and have it on 30th.
Okay. Third, Mr.
PK, my lord, Parthiv Kumar Goswami.
Parthiv Kumar Goswami, learned senior counsel,
My lord.
assisted by Mr. Kolita, learned counsel for the petitioner. Mr. Goswami, learned counsel for the petitioner, submits that he may be permitted to withdraw this civil revision petition and to approach this court again by filing appropriate petition. And also submits that the learned trial court has fixed a matter on 1st of July 2025 and till preferring an appeal before this court. No, till preferring an appropriate petition or appeal before this court. The petitioner may be granted liberty to approach the trial court to grant some time so that he can approach this court with appropriate application or appeal petition. In terms of this CRPIO stands disposal on withdrawal.
With liberty, my lord. My lord, with liberty.
With liberty. Yes.
Deeply obliged, ma'am. Deeply.
Pending item 24.
That judgment has got it, my lord.
Periamal.
Yes. My lord, Rahul Shah judgment has been quoted here in paragraph 73 and thereafter no objection has been made. This judgment I referred to yesterday, my lord. That has been quoted in paragraph 73. And thereafter, my lord, yes. At page
No,
73.
no, you now tell me, is there any direction necessary from this court?
My lord, yes, my lord, because already 11 months has expired, my lord. Now, Supreme Court has directed to dispose of within 2 months. So your losses may direct to
6 months.
my lord.
6 months.
No, this case, my lord, the existing, well, from 6 months from the date of filing. Here already 11 months expired, my lord. So last paragraph here also you'll see, my lord, that page 78, last
When
page.
the execution case was filed.
Yes, execution case was filed in August, my lord, 24, 8th of August 24. 8/8/24. Page 111. At page 115, my lord, that is that.
Okay. Heard Mr. Sayola, learned senior counsel assisted by Ms.
Aisagara.
Learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has prayed for issuing appropriate direction to the learned executing court to execute the decree, judgment and to execute the decree dated
My lord, yes. The decree, my lord.
28/9/1989.
29, yes.
89. Mr. Sahayullah, learned counsel for the petitioner submits that having obtained the decree on 28/9/1989, the petitioner has filed an execution case, being execution case, title execution case number 26 of 2024. And since then, more than 11 months elapsed.
On 8/8/24, my lord, page 193, my lord, is there.
180.
193, my lord, that order sheet is there.
Upon which title execution case number 26 of 2024 was registered on 8/8/2024, and since then almost 11 months elapsed.
Yes.
But the learned executing court has failed to get the decree executed and passed different orders dated 5/11/2024, 29/11/2024, 28/12/2024, then 19/2/2025, 24/3/2025, 29/3/2025, and 24/4/2025. Whereby the execution of the preliminary decree dated 15/11.
Final decree, my lord.
You come to page number 2. What you have written there,
Oh, I'm sorry, my lord, that, but High Court has said, my lord, final decree.
final decree.
Final decree, my lord, I'm sorry. That
The final decree dated 15/11/1989.
Yes.
No, you have mentioned there as final decree as 26/7/2024.
Yes. At page 108, my lord, High Court has said that the decree is a final decree.
The preliminary decree dated 15/11/1989 and final decree dated 26/7/2024.
Yes.
Passed in PS number 18 of 1982. 82. Has been needlessly time and again being delayed and postponed. Mr. Sahayullah, learned senior counsel for the petitioner referring to a decision of Honorable Supreme Court in Periamal within bracket date through LRS and others versus P. Rajamani and another, etc. In civil appeal number 3640-3642 of 2025 arising out of SLP within bracket C number 8490-8492 of 2020 submits that in the aforementioned decision, Honorable Supreme Court has directed that the execution proceeding shall be disposed of within a period of 6 months. And since in the present petition, in the present case, almost 11 months elapsed till filing of the execution proceeding, the learned trial court, executing court, contravened the direction issued by the Honorable Supreme Court. And under such circumstances, Mr. Sahayullah contended to issue direction to the learned executing court to execute the decree as soon as practicable. In terms of the direction issued by the Honorable Supreme Court in the case of Periamal, within the date through LRS and ORS, within the Supra. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition in the documents class on record and also perused the impugned orders dated 5/11/2024, 29/11/2024, 28/12/2024, 29/2/2025, 24/3/2025, 29/3/2025, and 24/4/2025. Passed in title execution case number 26 of 2024. Then the preliminary decree dated 15/11/1989 and the final decree dated 26/7/2024. It appears that having obtained the decree, the petitioner has filed title execution case, take title execution case number 26 of 2024 on 8/8/2024. Then since then, more than 11 months elapsed. While Honorable Supreme Court has fixed the timeline for disposing of an execution proceeding within 6 months, the impugned orders passed by the learned executing court appears to be contrary to the decision of the Honorable Supreme Court. And under such circumstances, this court is inclined to dispose of this petition by directing the learned executing court to execute the decree dated so and so as soon as practicable, keeping in mind the direction issued by Honorable Supreme Court in the case of Feria Multate to LRS and ORS. We are not fixing the timeline since Supreme Court has already fixed.
No, no, my lord, here, my lord,
Yes,
2
practical.
months, in this matter, 2 months has been given, my lord, for that purpose. The last page, my lord, your lordship may see para 79.
Para?
Para 79, last para, my lord, in the judgment. Last page. Because this is a pending case, that is why.
No, in this case, Supreme Court has given 2 months,
My-
but the direction is for 6 months.
Yes, my lord, from that of.
In terms of our discharge, are you sent disposal? The petitioner shall obtain a certified copy of this order and shall place the same before the learned executing court within a period of one week from today.
Item for admission, item 7.
Wait, please, Lordship. Lordship, matrimonial appeal against judgment dated 20 of March 2025. Well, thereby my petition was rejected, my lord.
Why?
My lord, the grounds Lordship will find at page number 25, my lord. My lord, Learned Fort below has held that the facts narrated cannot be a ground of cruelty, my lord. Page 25, Lordship will read the second paragraph on the top. The first ground of cruelty as cited above in our view, my lord. This is one of the reasons cited, my lord. Secondly, there was a criminal case filed against me, my lord, that wherein I got acquittal under 498A, alleging some illicit relationships, another third person, my lord. Both of us were acquitted, my lord. So that was my ground that it amounts to cruelty, my lord. At this stage, my lord, I will pray notice may be issued, my lord.
Heard Mr. Mishra, learned counsel.
No, my lord, I am T.R. Sharma, my lord.
Pardon?
I am T.R. Sharma, my lord. Tilak Ranjan
T.R.
Sharma.
Sharma.
Yes, my lord.
Okay. T.R. Sharma, learned counsel for the petitioner. No, learned counsel for the appellant. This appeal under order no, under section 28, which indicate 1 of the Hindu Marriage Act 1955 is directed against the judgment dated 20th/3/2025 first by the learned additional district judge Dibrugarh entitled Supreme number 5 of 2023. It is to be noted here that by the judgment in order dated so the learned additional district judge has dismissed the title suit number D number 05 of 2023. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated 28/3/2025. Admit issue notice to the respondent returnable in 4 weeks, that be taken by registered post with AD and also by usual process within the week from today. Registrar call for the record from the learned trial court.
Yes, my lord.
Release the
Additional
matter
disclosures
after
to court.
4 weeks. After 4 weeks.
I'm obliged.
Item 26.
May please, your lordship. Appeal against my lord, refusal of injunction. Although the tenancy agreement was executed between the plaintiff and the defendant, well, for the purpose of running a bar, my lord, the lordship will find the tenancy agreement at page 41. Initially, my lord, this tenancy agreement was for 3 years, and there was a condition in the tenancy agreement that the tenanted premises can be used for the purpose of bar only after obtaining valid license from the government. And therefore, my lord, initially the rent was fixed at 4,000. Subsequently, when the tenanted premises was ready for operation, the rent was enhanced and he was paying 8,000, my lord. Now, the page 43, my lord, kindly see, this is an NOC by the landlord for availing the license from the government for operating the bar, my lord.
Page number?
Page 43. After the tenancy agreement was executed, for the purpose of the tenanted premises, my lord, the landlord issues this no objection certificate, certifying that I have no objection on opening of the above said store on having proper permission from the government of Assam. So the purpose of tenanted premises will come into force only when the license is granted by the government. Now he applied for license at page 44 by paying an rupees 1 lakh as an application fee. Page 45 is the sanction order of the government of Assam, my lord. In the sanction order, your lordship will kindly mark one thing. My lord. Page 45, my lord finds. This is dated 2nd of March 2023. And the sanction was given to run the shop in the rented house of Pradeep Singh, that is the defendant, my lord. 4th line. My lord finds 4th line. I am directed to say that the government of Assam under Rule 116 of the Assam Excise Rule is pleased to accord sanction of IMFL on license for favor of so-and-so, son of so-and-so, in the rented house of Pradeep Singh, son of so-and-so, covered by Doug number so-and-so, for a period of 1 year, subject to renewal. Now, thereafter, my lord, the page 46 and 47 are the license fee and the security deposit submitted, amounting rupees 2,50,000 respectively, my lord, 5 lakhs total. Thereafter, the license was granted at page 48. And he was allowed to operate the shop from 27/4/2023. So meaning thereby, my lord, the purpose of tenancy has came into force on 27/4/2023. And after the license was given,
No, this license was for operation of the bar.
Bar in that tenanted premises. And the tenancy agreement executed for the purpose of operating that bar. But the tenancy agreement had a clause that the operation of bar will be subject to the license granted by the government. Though the tenancy agreement was executed in 2021, the plaintiff kept on paying the rent at the rate of 4,000 because he could not operate it without the license. Now, after the license, when he has made all the construction, done all the necessary renovations in the tenanted premises by expending his money, thereafter there was some public complaint by the local people. The appellant came up before this honorable court. This honorable court directed the deputy commissioner to take a call. The deputy commissioner passed an order allowing him to operate the bar. Thereafter, the defendant was restraining him. The landlord was restraining him. He filed this suit seeking a declaration that he has a right to operate the bar in terms of the tenanted premises. And there was an injunction application also filed restraining disposition of the plaintiff from the tenanted premises and not to let out the premises to anybody else. Now, in the written statement, the landlord, the defendant, has admitted that the plaintiff is in possession. Now, despite that, without discussing the three principles of the injunction, my lord, prima facie case balance.
The perusal of the impugned order, it appears that the trial court has discussed all the principles.
No, the balance of convenience has not been discussed, my lord. My lord, the trial court determined the lease on the injunction application. Though, my lord,
No. In order to find out the prima facie case, why the trial court cannot discuss about the tenancy agreement?
no, it can. My lord, the dispute which has came before the court.
The mere discussion, directing a discussion cannot be said to be determination of the issue.
No, the issue which has been before the court, the defendant admitted the execution of tenancy agreement, but contended that this tenancy agreement was executed for the purpose of running a garment shop, not a bar. And he admitted.
Where is the tenancy agreement?
Yes, tenancy agreement, your lordship will find at page 41. And page 42, the purpose of tenancy, my lord will kindly see. Clause 5. Specifically, it is written as shall be used for beer bar on having a proper license permission from the government of Assam by the second party. And till February 2024, in fact, the trial court has recorded that till February 2024, the rent was being accepted by the landlord without any objection.
Where the period is mentioned?
My lord, the period is mentioned at clause 1. Initially, for a period of 3 years from the 1st of July 2021, the tenancy shall come into effect from 1st of July 2021, initially for a period of 11, and to be renewed thereafter by mutual understanding between the parties. In fact, the trial court has categorically gave a finding also that by way of a mutual understanding, it was extended time to time.
Where is the document to show that at the relevant point of time it was enforced?
My lord. Lordship will kindly
At
see.
the time of filing the suit, the agreement was enforced.
Yes, my lord will kindly see page 158, the finding of the court, my lord.
Page number?
Page 158, para 16. There is a categorical finding of the court, my lord. Or the opposite party has not submitted anything clearly whether the tenancy has been lawfully terminated or not. Here, the petitioner has claimed that he has a right to possess the scheduled tenanted premises and to operate the restaurant cum bar on the basis of this agreement. The right of the opposite party over the suit premises will sustain so long as the tenancy agreement is in force. The right to possess the suit premises will get affected as soon as the tenancy agreement gets terminated. From plain reading of the tenancy agreement, if we consider the term as of for 11 months, the parties must have to agree for renewal after lapse of every 11 months. The opposite party has not disputed the receipt of the monthly rent up to February 2024. And as such, it can be presumed there was a mutual agreement for renewal of tenancy up to year 2024. Prima facie, the very agreement on the basis of which the right to possess the premises has been sought has already expired on 1/7/2024 if we consider the term of the agreement as for 3 years as mentioned in the face of the agreement. So, my lord, this was not even a case of the defendants. Defendant disputed the tenancy agreement, the purpose of the tenanted premises. And if your lordship will kindly appreciate,
if the tenancy agreement expired on 1st of July 2024.
Yes.
Then on the date of filing the
no, it was
so the agreement,
this suit was filed on 28th of May 2024. This suit was filed on 28th of May 2024. Page 36. After the suit is being filed. And if your lordship will kindly see page 33, Miller, my prayer, Miller. Prayer in this suit, Miller. Declaring that the plaintiff has a right to possess the scheduled tenanted premises and to operate the tonic bar, restaurant and bar therein. Declaring that the plaintiff has a right to operate the tonic restaurant bar in terms of the tenanted premises since 27/4/2023 in terms of the agreement of tenancy dated 1/7/2021. This 27/4/2023 is because there is a condition in the tenancy agreement that he can run the bar only after obtaining license. The declaring that the defendant illegally restrained the plaintiff from opening and operating the tonic bar, restaurant and bar in the tenanted premises since 27/3/2023 and thereby breached the terms and conditions of the agreement dated 1/7/2023. Declaring the plaintiff has entitled to recover the compensation for the breach of the compensation part. So, in the written statement, my lord will kindly appreciate, even the written objection to this, the injunction, your lordship will find there is no denial to any of the statements made in the injunction application. Written statement, my lord will find at page 102. My lord will kindly see paragraph 8, page 103. This is in response to the statement made in the plain that the tenancy agreement was executed for the purpose of operating that bar. In reference to para 4, it is a fact that the pursuant to offer an acceptance by and between the plaintiff and defendant, they both entered into an agreement of tenancy dated 1/7/2021 for a period of 3 years commencing from the date of agreement for clothes shop. The execution of that agreement has been admitted, but the purpose of tenanted premises has been disputed. Now, my lord will kindly see paragraph 9, my lord. Again, it is an admission that the possession was handed over for making the necessary arrangement and renovation inside the tenanted premises. Para 9, page 104, my lord finds. The defendant thereafter handed over possession of the tenanted premises to the plaintiff in order to make necessary arrangement and renovation inside the tenanted premises as per his requirement to open a cloth shop. So the dispute was, it was not tenanted for, tenancy was not executed for opening a bar, but for a clothes shop. In paragraph 29, page page 113. My lord finds 5th line. It is true that the tenanted premises is still under the possession of the plaintiff. A defendant has not filed any counterclaim, my lord, for eviction. And without a decree, my lord, he is not entitled to evict me, my lord. Even it is not his case that I am a defaulter of rent or he needs the tenanted premises for his bona fide purpose. He disputed the purpose of tenancy. And there was an injunction order, ex parte injunction order granted by this honorable court, which was continued, and your lordship remanded the matter back to the trial court for deciding, as the written statement and written objection was filed in between. The earlier injunction order passed by this honorable court, your lordship will find Page 101. Page 101, last paragraph. The respondent shall neither take any steps to evict the applicant from the suit land, nor he will try to let out the house to another person. Now, this was subsequently extended by your lordship at page 156. Sorry, 148. Till disposal of the injunction application at page 149.
Okay, we'll see. Here, notice, we will admit the appeal.
My lord,
We will issue notice.
my lord.
And,
I have also an injunction.
IA will see. What can we do?
Well, at this stage, my lord, status quo may will. Well, that will
We'll
protect me.
see, we'll see.
My lord.
You have submitted that the balance of convenience was not discussed by
Not
the
discussed.
trial court.
Not even a
Then,
single line about
therefore,
that.
again, we will peruse the impugn order. We'll see.
My lord.
Heard, Mr. Kosik, Burnett, counsel for the appellant. This appeal is directed against the judgment, against the order dated 9/6/2025 of the learned civil senior division. Preside. In Ms. J case number 27 of 2024 arising out of PS number 35 of 2024. Peruse the memo of appeal and the grounds mentioned there. And also peruse the impugn order dated 9/6/2025. Admit issue notice to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by result process. We can welcome to that. Place the matter after 4 weeks.
Well,
After 4 weeks. We will see.
well. In para 18, my lord, the findings of the court, my lord. Only
Para
with regard to para 17 and 18, only with regard to prima facie case. Even the court did not take into.
The trial court has discussed.
My lord, in my respectful submission, my lord, it would be in contrary to the finding, the proposition, the definition of prima facie case as said by the Honorable Supreme Court, my lord.
Okay. We'll resume after 5 minutes.
Grateful. Please, your lordship. The IA has been filed for variation of the order which your lordships.
For?
Variation and discharge of the order which your lordships had passed on 11th of June.
On what ground?
Well, the basic ground on which the order was passed, that is reflected in paragraph 13 at page 188. Now, if I can read it out to your lordship, my lord.
Paragraph?
13, page 188. In respect of the interim prayer, this court has taken note of the submission of the learned counsel for the parties. More specifically, the fact that the petitioner is a widow and living in the Tinchali house with her daughter, and that if demolition of her only shelter is carried out, she would be rendered homeless. So this was the basis of your lordships passing the interim order, by which the execution was stayed. Now, if your lordship will kindly come to the page 27, my lord, your lordships have also seen this on that day I had shown to your lordship, but just for the purpose of formulating my point, my lord, I am just taking your lordship again to that particular page. If your lordship will kindly come to page 27. Page 27 describes my case before the trial court, paragraph 6. Plaintiff is entitled to a right of way from their house over the path to the municipal road
situated to the north of the plaintiff's house as shown in the rough sketch map annexed to the plain.
Hmm.
Now this path which leads to the municipal road from my house, that has been described as Schedule B in the plain.
Hmm.
And over this path, my lord, I have sought the easementary right. Now this sketch map is at page 33. Now here, my lord, 571 Dag is the Dag of my house. And 572 and 573 are two Dags, my lord, which belong to the defendant.
Hmm.
And in between 572 and 573, this is the Schedule B path, which connects my house to the municipal road.
Hmm.
This is the only exit that I have. Now, this Schedule B, over this Schedule B path, my lord, the suit has been filed claiming my easementary right. And this Schedule B is 10 feet in width and 80 feet in length. Now, the projection on that day was given to your lordship that over this Schedule B path, the defendant is having her only homestead. And if this demolition is carried out, then she will be rendered homeless. That was the projection given to your lordship. But my specific case was that, and it has been still that over this path, my lord, she doesn't have any house of residential house. Now, how do I show that to your lordship, my lord? That day I was little handicapped because at the beginning I also indicated that all the materials were not placed before your lordship. Now, if your lordship will kindly come to page 47.
But my lord,
Page. Just a minute. Let me complete. Please begin thereafter.
One by one, please, you sit down.
Now,
Page number?
if you page 47, my lord, page 47 is the petition, my lord, where I prayed for the injunction before the trial court, and the injunction was granted. And eventually, my lord, by 16th May 2016 order, that injunction was order of injunction was set aside by the First Appellate Court. Now, as against that First Appellate Court's order, my lord, I had come before the sorry, my lord, as against that order, my lord, I had come before the Honorable High Court and filed a CRP. Filed a CRP. Your lordship will kindly see page 62 is the order which the Honorable Court had passed on that particular day.
62.
Page 62, your lordship will pay, the operative part will be at page 63. Now, last paragraph, till the returnable date, operation of the, has your lordship got it, my lord? Operation of the impugned appellate judgment and order dated so-and-so passed in miscellaneous appeal number so-and-so by so-and-so shall remain stayed and parties shall maintain status quo with respect to the suit part. The injunction trial court grants me status quo on the date of moving the injunction petition, subsequent to the moving of injunction petition. Injunction was granted in my favor. The defendant goes before the First Appellate Court and gets the order set aside. I approach the Honorable High Court. High Court restores the status quo as on that day. This order was passed on 17th of June 2016. So therefore, till 2016, my lord, one thing is clear that over that Schedule B path, there was no question of any construction, no question of any homestead land. Because injunction order was passed in favor of myself on 26/3/2015. Page 44 is the injunction order. The projection before your lordships was made on that day that she has her only homestead house over this Schedule B path. Page 44, your lordship will kindly see, this was the injunction order. And the injunction, after the injunction order was granted, they carried it on appeal. In the appeal, the injunction was vacated, but the Honorable High Court passed an order of status quo in the year 2016. Now thereafter, in course of happenings, my lord, the trial court ordered, there was violation of the status quo order by them, my lord, and therefore the trial court ordered execution of the status quo order. That order was executed on 28th of May 2018, page 70, that your lordship will kindly see. Page 70, your lordship will kindly see. This was addressed by the IC Mongoldoy PS to the Honorable Court of Munsif number 1. In inviting a reference to the subject cited above, I have the honor to report that as per your order dated 21st of May 2018, the status quo order has been executed to remove the detrimental objects found over the suit path, measuring 10 feet in breadth and 80 feet in length out of an area of so-and-so covered by dag number so-and-so, patta number so-and-so, submitted for your favor of your kind information and oblige. Now, in the next page, my lord, the schedule of the clearance, obstructions, clearance from the cleared from the suit path is also mentioned. My lord, this is the exact schedule of Schedule B in my suit. So, in the year 2018, my lord, there was the obstructions were cleared, and the suit path, status quo over the suit path was restored. After that, my lord, page 77, page 74, your lordship will find my petition before the trial court complaining that she has again erected construction over the suit path. Page 74 is the order passed by the learned trial court. And that is very important, my lord. This requires some consideration by your lordships. My lord, page 74, I am just reading it out to your lordship. My lord, seen the petition number so-and-so by petitioner so-and-so, along with documents submitting that the opposite parties have erected a wall on the suit path, that thus preventing his egress and ingress altogether. Hence, he has prayed for removal of the concrete wall that was erected by the opposite party, heard perused case records. Now, one thing your lordship will kindly note, that May 2018, the suit path was cleared. The status quo was restored to me, pursuant to the order of the Honorable High Court and the order of the trial court. Now, she again created an obstruction. She blocked my road by creating a wall, and therefore I had to again approach the trial court. Now, this situation, my lord, this order was passed. Perusal of the case record discloses that the opposite parties have been causing disturbances on the suit path despite order from Honorable Guwahati High Court dated so-and-so. My lord, this order I have read out to your lordship. White said ordered, Honorable Guwahati High Court ordered the opposite parties to refrain from causing disturbances on the suit path. Again, wide order of this court dated so-and-so, the status quo, the order dated so-and-so was directed to be executed through SP Dorong. Said order was duly executed, and compliance report thereof shows that the execution was done in presence and with consent of the opposite parties. Today, the petitioner has again sought the intervention of this court in removing the disturbances caused by the opposite parties. Case record discloses that path concerning which the opposite parties had allegedly erected the wall after execution of order dated so-and-so is the subject matter of the suit. Therefore, preservation of the suit path as it was on the date of filing of the suit is absolutely essential for the trial court to arrive at a just adjudication. Moreover, the documents, photographs of the suit path relied upon by the petitioner shows that the suit path has been completely obstructed by the opposite parties by their overt act of construction of the concrete wall, thus at the same time entirely preventing the petitioner from egress and ingress to his homestead. Also seen the report of the OC Mongoldoy PS, which also shows that the opposite parties had blocked the suit path entirely by erecting a concrete wall. Said report be kept with record. Now, therefore, I'll skip the next paragraph, the paragraph in bold. Therefore, in exercise of inherent powers of this court and for the ends of justice, I hereby direct that the concrete wall erected by the opposite parties on the suit path be demolished to the ground and restored the suit path as it stood on the date of the suit. After this, my lord, this order is also made subject matter of challenge before various forum. Ultimately, it lands up before this honorable court in the form of a CRP. Now, in that CRP, and before the CRP, my lord, there is also another order which is at page 77. And in page 78, your lordship will find there for the first time this teen chali comes into existence. From 2013, my lord, the suit is going on concerning the suit path. There was no homestead on the suit path till the year 2016, 18, 19. And suddenly before this honorable court now, the teen chali residential house comes into existence. Now page 78, third paragraph, your lordship will kindly see. The petitioner has contended. Has your lordship got it? The petitioner has contended that on 20/01/19, Lovita Das, the wife of deceased Kaushik Das, had obstructed the suit path and erected barricade made of bamboo and tin on the entry and exit point of the suit path, and also constructed concrete wall on the entry point of the suit path, and therefore it has become impossible for the petitioner and his family for his ingress and egress through the suit path. Now this part is I am indicating only to show that how this tin shed and tin shed construction came into existence. Although on previous occasion, my lord, there was barricades put and it was cleared through execution. I mean through execution by the police, my lord. This has come. And paragraph page 79, your lordship will kindly turn to next. Page 79, fourth line from top. The paramount consideration at this juncture is that the status quo order, which was passed by the trial court on 26th March 2015 and affirmed by the Honorable Guwahati High Court by order dated 17/6/2016, has been complied with by both the parties and there is no violation of the status quo order. The OC has also enclosed, my lord, this was pursuant to the execution carried out in the year 2018. OC has also enclosed a letter with his report dated so and so, so and so. Next paragraph, your lordship will find. Further, the OC Mamoldoi has also submitted in his report that an old gate is blocked by a concrete wall and tin. Now, from the perusal of the photographs appended by the OC concerned, it clearly transpires that there is a concrete wall and tin barricade which have been constructed on the side of the opposite party blocking the gate, which is on the side of the petitioner. Thus, the report of the OC concerned reveals that the suit path has been obstructed by the opposite party by making constructions. It is worthwhile to mention that despite having knowledge about the status quo order with respect to the suit path, earlier on 3 occasions, the opposite party, Kaushik Das is the deceased husband of the present defendant, my lord, had obstructed the suit path, and accordingly my learned predecessor by orders dated so and so, so and so, so and so had directed to remove the constructions on the suit path with the assistance of the police personnel and to restore the suit path as it stood on the date of the suit. So this is done by the learned trial court, and thereafter your lordship will find the story built up regarding the residential house, how it has come, that has been recorded by this honorable court in the order passed on 24th of March 2024, which is at page 126. And paragraph 15 at page 134 is the relevant paragraph where the defendant's counsel himself had admitted that the constructions were carried out after passing of the status quo order. Paragraph 15, your lordship will kindly see. Moving forward, it is also seen that during pendency of the suit and as submitted by Mr. N.K. Kalita's line counsel so-and-so on behalf of the respondents that during the period after passing of the first appellate court order and before passing of the status quo order by this court on 17 June 2016, the defendants have made certain construction by raising a tin chali house. So, my lord, 17/6 order also I have shown to your lordship. And this has come from none other than her counsel himself, that this was constructed in between the time the first appellate court passed an order and the Honorable High Court repeated the status quo order on 17th of June. Now, in this premise, my lord, it has been suggested by this honorable court, it was suggested by this honorable court to cause an inquiry, and if it is found that this cannot be restored, the suit path cannot be restored otherwise by then demolishing the constructions, my lord, it has to be done by the learned trial court. The trial court has now done that only, and kindly see her written statement before the trial court. Well, the story of this residential house over the suit path measuring 10 feet in width has been built up for the very first time now. It was nowhere in existence before the trial court, nor even at the appellate stage which was filed at the stage when the injunction order was challenged. Now, her written statement, your lordship will kindly see at page 104. It starts from page 100, but 104 about fifth line, third line. The allegations made in the para. Your lordship got it, my lord. The allegations made in the para that toward the eastern side of the path, there are residential house of the defendant number 1 to 3 are not wholly true and correct. In fact, this is important. In fact, toward the eastern side of DAG number 572, DAG number 573 is situated, where the defendants have their residential house. Now, if your lordship, just for a bare eye comparison, if your lordship will kindly come back to the sketch map at page 33. If your lordship will kindly come back to page 33, my lord, her statement is that in the WS before the trial court that their residential house is in the DAG number 573, which is to the eastern side of the 572. Because to the north is the municipal road. And in the next sentence, my lord, she says, it is however admitted, page 104, it is however admitted that the plot of land over which the defendants reside is fenced on all sides of the plot, that is DAG number 572 and DAG number 573. She gives a projection in the trial court that 572 and 573 are bounded on all sides by fence and there is no road in between. But she makes it very clear that the residential house is in the DAG number 573. Now, how come this statement is made before this honorable court? My lord, it's a daring attempt to take the honorable court by a ride, to contend that her only residential house is on over the suit path schedule B. If the suit path schedule B is the place on which her residential house is there, when was this constructed? Right from the inception of the suit, there was no existence of any house over this plot of land, over this strip of land rather. This statement, my lord, it's a clear fraud, my lord. I'm saying with all responsibility, my lord, it's a clear attempt to wooding this honorable court. It's a daring misrepresentation of fact. And I can show it to your lordship, my lord, neither before the first appellate court nor before at any other rounds before this honorable court, they made this statement. Rather, their statement was that this construction was made. Paragraph 15 in the 24th March order, my lord, the categorical statement was that it was a construction over the suit path was made after the first appellate court passed the order, cancelling the injunction, and the Honorable High Court revived the status quo order in the year 2016. Wherefrom, my lord, this statement comes that it is the only residential house. And that was the projection given to your lordship.
Mr. Dotto, why we cannot hear the main petition and finally dispose of the same instead of hearing the IAC?
My lord, in fact, my lord, my endeavor on that day was just like this, that they don't deserve any hearing in this CRP at all. The consecutive acts they have committed right from the beginning, and that they have been complaining of.
Later on, you have not submitted the documents which you have brought with you, and therefore.
No, my lord, there is one thing. An officer of a court is also a responsible person. Lord, merely because I have not submitted the document or I have failed to submit certain documents on that day, that does not authorize a petitioner to say something on oath, which he knows that, knowing fully well that this is false. My lord, she swears this petition before your lordship on oath, supported by an affidavit, knowing fully well that the statements that she is making in the petition is false. No, my lord, is it, she is approaching a court of equity, my lord. Is it justified for a person, for a petitioner, for a litigant to make false submission before the honorable court and merely on the strength that the other side will not object?
No, no. On the other day, he also only praised for interim relief.
No,
There is
question is, my lord, the question is,
There was-
interim question of granting interim relief
No,
will
no,
come.
no, there was no submission on either of you that it should be finally heard and disposed of on that day.
No, my lord, I only registered the prayer of interim relief on that day, and that was on my oral submission as well as on the basis of the materials that they had brought on record, particularly the last order passed by this honorable court last year, that I said that this particular statement that there is a residential house over should be is not borne by the records. And therefore that there should, my lord, your lordship's indulgence was invoked, my lord, only with the factual premise that she is a widow lady and this is the only residential house which is standing over Schedule B path. My lord, is it a correct statement on record, my lord? I asked to myself. My lord, if I am approaching your lordship, is it not my responsibility to approach your lordship with clean hands? Is it not unbecoming of a petitioner that she will file petitions and she will make statements the manner she likes? Lord, it is very regretful aspect of the matter that such a thing has come, and it is on my insistence that I had to bring this to. She has filed a written statement in the lower court, my lord, asserting her existence of residential house elsewhere, and in the High Court she is making a bold statement like that my only residential house is over this 80 feet by 10 feet land. Is it believable? My lord, my lord, an extraordinary jurisdiction of your lordship should not be invoked just like that. A party approaching your lordship should at least show some regards to the sanctity of the procedure. And why am I required to read out these many orders to your lordship? Had she not misrepresented the facts, my lord, I would not have required. I am in a civil division petition, my lord. I have put up 32 years in the bar, my lord. In the past we never had a practice of filing an affidavit in the CRP. But because of the changed circumstances, my lord, the situation has come to this pass that we are required to file affidavit in CRPs because the facts are not pleaded in the manner it should be done. At least some a petitioner approaching your lordship should show some responsibility in placing facts.
No, this is the standard of today's bar.
Well, that's why I'm saying.
What to do?
My lord, that's why some strictness from your lordship is warranted. My lord, that's why I am saying I have put up 32 years, my lord. This was not a practice in this bar. We never used to file any affidavit in the CRP because we used to be in the belief that the things will be placed in the proper manner and there will be no misrepresentation of fact. That was the standard we grieve in. Unfortunately, my lord, this has come to this. And therefore, my lord, some strictness from your lordship is also warranted. Well, these should not be allowed to go simply like that. There should be a warning from your lordship.
Let us do one thing. We fix it immediately after reopening. We will finally dispose of the CRP.
Absolutely fine, lord.
Yes, my
That
lord.
will
My
be
lord,
better.
only objection I have, my lord, very strict orders are being placed, my lord, saying that we have placed wrong things. My lord, I object to that, my lord. And there in the petition itself, my lord, learned senior friend, what he has said, my lord, kindly turn to page 18 of the petition, my lord. There has been a personal attack. Kindly see, my lord, page 18. My lord, we always respect, my lord, years of practice, my lord, but this is also a thing, my lord. Page 18.
Yes.
My lord, it is an act, second line towards the end. It is an act, and it is an afterthought and misleading statement made before this honorable court on 11/6/25 during arguments by the counsel for the opposite party.
Yes, obviously it was made by you.
I have to reply.
Paragraph number.
Sorry.
Well, it is
Paragraph
37.
number.
37.
This paragraph number 37 at page 18 of the petition.
Page 37.
Yes.
No, para 37.
Yes, para 37, page 18.
Yes.
On the top, my lord, second line,
Yes.
it is an afterthought and misleading statement made before this honorable court on 11/6/25 during arguments by the counsel for the opposite party that the opposite party along with her minor daughter is residing at the Tin Sali house. My lord, as if this statement was made in this court by the counsel while arguing the case, my lord. That was the projection. This is a personal attack on me, my lord. I will now say I have stated this from record, my lord. Why, my lord? As my learned senior has just read out, kindly turn to, my lord. Let me take up our petition also, that High Court's order. In High Court, para 15, just it has been read at, my lord, page 134, my lord. My lord, this is a personal attack and I need to reply, file a reply by way of affidavit, my lord, to this. Because whatever was stated before this court, as he has pointed out, was on affidavit by the petitioner. Being appearing on her behalf, I have to
My lord,
place it.
I must
It
clarify,
cannot,
my lord,
my
it is not an attack on him, my lord.
My lord, what is
It was a
this?
submission made on behalf of the
What is this, my
petitioner.
lord?
It is only an exposition of that.
My lord,
He
standing
made a
boldly
submission,
in the
whatever
court,
submission
someone is
he had
saying, I
made,
have
that was on the
32 years of
petitioner.
practice and this is the statement made against a junior counsel. I am quite junior to him, my lord. My lord, this is the bold statement made in this court. I object to this and I have to file an affidavit because this will go on record against me. How can this be, my lord? My lord, the petitioner, okay, I have gone through that statement. Some statement was made. There are 11 or 12 or 17, I don't remember, defendants. Maybe, my lord, by copy paste, something has happened. I will come, my lord. Kindly turn to page 134. This is the statement made by the counsel for the petitioner before the court, and that is been recorded that when the status quo was vacated and when this was reimposed by the court again, during that period, there are some Tin Sali house constructed, my lord. This is in the observation of the court. Pursuant to this, my lord, there was a commission caused by the court, High Court. And that commission report, lordship, kindly turn to page 147. I'll read 2 pages, my lord. I'll read out. Lordship, may kindly turn to page 145 first. This is the translation copy given of the commission report. Starts at 144. My lord, this reading will show why these affidavits are required. Lordship, 144, kindly turn to page number 145. I have read this 3 times on that day, my lord, on 11/6. Kindly turn to page number 146. My lord, the 1, 2, 3, 4 line, it is mentioned that. Has your lordship got it?
Page number?
Page number 145, the 4th line from the top.
Okay.
My lord may read the vernacular at page 147.
Definitely, my lord.
That will
Definitely,
become
my lord.
easier.
He has got it. He has got it what I want to project. My lord, this was translated by me also in my petition, my lord. It is there, but I will read his translation. It is mentioned that Lovita Das constructed concrete wall and tin wall on the common boundary of Robinde and Lovita Das. And it is also seen that there is a concrete wall in the side of the Subroto Das. Moreover, on the southern side of the said plot, Lovita Das constructed Sali house along with old house for which the ingress and egress cannot be seen. On the aforesaid land, as mentioned in the suit, on the remaining part, there is seen, there are, pausing here for a moment. Well, what the translation said, there is a Tin Sali house and connected with an old house, Assam type house. Now, lordship will kindly turn to page number 147. The vernacular, what it exactly says. My lord, if possible, my lord, I will read at the bottom, my lord, that number of the persons given 1, 2, 3, 4. Anhate Paschim Dikhot, has your lordship got it? In the middle of that.
Yes, yes.
Yes. Anhate Paschim Dikhot Subrata Das মৃত চিত্তৰঞ্জন দাসে এটি ঘৰ সাজি দখলত ৰখা দেখা যায়। প্ৰকাশ থকা যে ৰবীন্দ্ৰ আৰু লভিতা দাসৰ সীমাত লভিতা দাসে পকীৰ চৌহদৰ বেৰ ও টিনৰ বেৰ নিৰ্মাণ কৰি ৰখাৰ লগতে সুব্ৰত দাসৰ অংশত এখন পকীৰ বেৰ থকা দেখা যায়। তাৰোপৰি উক্ত চৌহদৰ দক্ষিণ ফালে লভিতা দাসে পুৰণি এটি গৃহৰ লগত টিনৰ চালি সংলগ্ন কৰি ঘৰ সাজি বসবাস কৰা অনুসৰি উক্ত ডাগৰ গোচৰ বৰ্ণিত অহা যোৱা পথ দেখা নাযায়। মানে this is a report given by the circle officer. I have been residing in the Tinsali house. This is the report. But my lord, if the translation we read that we have been staying is been omitted from that, maybe by lord, my mistake. We do not know, my lord. My lord, projection has been made. And this statement is also made in the petition also that we have constructed a Tinsali house. But we are residing there as reported by the circle office while the commission was posed by this Honorable High Court. And based on these documents, my lord, I am saying where residing, I am a widow. I have a daughter who is studying in class 11. My lord, though this is not of relevance, my lord, there are other cases between the family members, my lord. This is on record. One appeal is also filed, not connected with this case, my lord. Why I am saying so? He is now projecting they have other houses. Yes, this report also says there is Assam type house. My lord, there are 17 plaintiffs. I am only one. I am being targeted. I will be out of the house. Based on these reports, those were placed on that day before your lordship. These were considered. And thereafter this was made, and it is stated in the petition on affidavit, my lord, that I have made a misleading statement in the court that is my only house. What proof they have that I have several houses? Simply by saying it is not there. I'll read what are the petitions, my lord. Everywhere they are saying the concrete wall has been constructed. If I have constructed a Tinsali house on the suit path, there has to be an objection under 39 Rule 2A. I'll read what are the lordship may kindly turn to. Yes, my lord. Before that, there was a statement made today, my lord, that earlier it was suit was cleared as per execution of this. That is at page 70, my lord. Kindly turn. Page 70, my lord.
Yes.
Learned friend just read it, my lord. Page 70, annexure 10 it is. In inviting reference to the subject cited above, I have the honor to report that as per your order dated so and so, the status quo order has been executed to remove the detrimental objects found over the suit path, measuring 10 by 80 feet in length out of an area 1 katha 5 lesas covered by so and so, ward number so and so, submitted report so and so. Along with this, these reports are submitted. Report submitted by the circle officer, Mongoldoy Revenue Circle, that I have already annexed and read that, my lord. That is as annexure 72. Again, this is a translation. Lordship may kindly turn to the vernacular at 73. We'll read the vernacular. This was in, my lord, 2000. This was in 2018. I will read the vernacular. উপৰোক্ত বিষয়ৰ সন্দৰ্ভত সন্মান সহকাৰে জনাও যে মহামান্য মুন্সিফ আদালতৰ চুৱেঞ্চ গোচৰত ৰঙামাটি মৌজাৰ বৰ্ধিত মঙলদৈ বৰ্ধিত টাউনৰ 402 নং ম্যাদী পাট্টাৰ 572 নং দাগৰ 10 ফুট বহল আৰু 80 ফুট দীঘলৰ ৰাস্তা এটি মুকলাই দিবাৰ বাবে মঙলদৈ আৰক্ষী চকীৰ টাউন উপ পৰিদৰ্শক মহোদয়ৰ লগত সৰজমিনলৈ যোৱা হয়। সৰজমিনত গৈ জোখমাখ কৰি দেখা পাওঁ যে ওপৰত উল্লেখিত মঙলদৈ বৰ্ধিত টাউনৰ চুৱেঞ্চ দাগ পাট্টাত 1 কথা 5 লেছা মাটি 4 জন পাট্টাদাৰৰ নামত চলি আছে। পাট্টাদাৰ ক্ৰমে চুৱেঞ্চ প্ৰকাশ থাকে যে উক্ত মাটিত ভূমিলেখ্য নথিমতে 1 নং পক্ষ ৰবীন দে নামজাৰি নাই। হি ইজ দ্য প্লেইণ্টিফ ৰবীন দে। মেপত উক্ত দাগটোত কোনো ৰাস্তা অংকন নাই, কিন্তু মহামান্য আদালতৰ হুকুম মতে 572 দাগৰ পূব সীমাৰ পৰা 23 ফুট ৰাস্তা এৰি 10 ফুট বহল আৰু 80 ফুট দীঘলৰ ৰাস্তা এটি গোচৰৰ দুয়োপক্ষৰ সন্মুখত জোখমাখ কৰি মুকলাই দিয়া হ'ব। মুকলাই দিয়া ৰাস্তাটো ট্ৰেছমেপত সংলগ্ন কৰি দিয়া হ'ল। My lord, I projected, lordship remembers that rough sketchment. Now lordship will kindly turn, that will be at page 54, I think, my lord, of this petition. 33. Sorry. This report says, my lord, 572 নং দাগৰ পূব সীমাৰ পৰা 23 ফুট এৰি at page 73. Now turn to, my lordship, kindly to page 33. Each side is this side, my lord, side can be seen on the 572 Doug starts, Doug number 573 and 572 are adjacent. There is no passage. This Doug is in 572 as per the schedule also. Now, if we leave this 23 feet from the eastern corner of the Doug number 572, then it, my lord, comes somewhere here. Is it not so, my lord? because it is at the eastern corner of the 572 duct, as per the rough math. Now you will leave 23 feet, it will come somewhere in the middle or towards the end of this western side. And that was by consent of both the parties, as reported by the circle officer. I pointed out, my lord, that there were two circle officers report. And prior to this High Court's order, wherein we admitted that there was a construction of Tinsali house during vacation of the status quo order, that cannot be said to be illegal. My lord, suit has not come to a finality, my lord. It's an status quo order and court says resume that status quo order. Now, during vacation of the status quo order, before reimposition, if sub construction is there, that cannot be demolished in execution of this order, my lord. That is there, and nowhere it is stated that no allegation. Even they ought to have come, if there is a construction over the footpath, there has to be a petition violate saying that yes. So, my lord, I strongly oppose this, my lord. There is a misrepresentation on my part. This is totally incorrect, my lord. This is given only to a given impression that we, the junior advocates, are doing so wrong, my lord.
My lord,
This cannot be, my lord.
my statement cannot be understood in that way.
I have understood that way, my lord.
No, that is your lack of understanding. My lord, all along I have been saying that it is the responsibility of the petitioner. Not for a single moment, my lord, I have uttered any word against him. I understand, my lord, he represents a client, so naturally he will have to take the client's side. Oh, that is often we do. But that doesn't mean that the petitioner will make a statement so bold and he will try to take the court by a ride. Question is that, my lord, this is an admitted fact that after the injunction order was vacated by the lower appellate court, and before the injunction order was restored by the Honorable Court, my lord, there was a construction. The endeavor of the courts have been to remove that part of the construction only. Now, how come you make a statement in the petition? You means the petitioner, not my friend. How come you make a statement in the petition that this is the only residential house that that belongs to me? You make a statement before the trial court that my residential house is at duct number 573. How can you make a statement contrary to the records? And contrary to admission by your own appointed counsel in the previous round of litigation, that this construction has come up in between the time after it was vacated by the lower appellate court and before it was restored by this honorable court. The honorable court's order, which I have read out to your lordship, my lord, that order is very clear. It only says that if
Mr. Dutta, you have already shown it to me. Anyway, let us fix it that we'll finally hear and dispose of the CRP.
Yes.
Immediately after your
By last order, it was directed to be listed after 4 weeks, my lord. As per 16-11-6.
naturally it will be 4 weeks by that time.
Under 39-4, this petition, my lord. Lordship has passed an order under 227 and 115 CPC. There was no injunction. This has been filed. This present petition has been filed for vacation or change of that under 39-4, which person not
anyway, we will hear both the petition on that.
Yes, my lord.
Yeah. Immediately after.
And Lordship also called for the records by that order itself. You can see.
Huh?
My lord, we feel hurt, my lord, if we are being attacked personally, my lord.
No, my lord, this should not be repeated, my lord. For the third time, I am saying that there is no attack against him. Why he is making a point out of it?
I will not repeat. I file an affidavit, my lord.
I am repeatedly saying that it is not against him, it is against the petitioner. Why he is taking it so personally?
No, sorry.
Maybe
17. Yes, okay.
Obligation.
Heard Mr. Dutta, learned assisted by Mr. Ayum, learned counsel for the applicant in IN number 2054 of 2025 and Mr. Sarma.
Yes, ma'am. Yes, sir.
RS Sarma.
TR.
Sarma. Sarma. Learned counsel for the respondent in IN number. Third in part, list the matter along with CRP number 208 of 2025 for final consideration on
17.
17.
Obliged.
Lordship's order dated 18th of June, Lordship. Pursuant to Lordship's order, Lordship, the petitioner got 3 months salary, Lordship.
You got 3 months.
3 months. Current salary, but area salary yet to be posted.
Okay. Mr. Sharma, what is the stage of this area salary?
Regarding the area salary, my lord, the inspector of school has sent a proposal to the DSC. Now DSC will verify his proposal, and then it is forwarded to the government.
No, can we expect a timeline?
2 weeks maybe guaranteed to verify the matter, my lord.
weeks.
Area salary proposal submitted by the inspector of school.
2 weeks.
Yes.
Okay, 2 weeks
Lordship,
after reopening.
Lordship.
Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. U. Sharma, learned standing counsel for the respondent. In respondent contempt of Mr. Islam, learned counsel for the petitioner, made a statement in the court that the petitioner has received 3 months salary, current salary, 3 months current salary, and that he has not received the area salary. At this instance, Mr. U. Sharma, learned standing counsel for the respondent contemporary Homestead. A proposal has already been sent to the Director of Secondary Education by the Inspector of School DDC Dhubri for a sum of rupees 6,66,400. Then the proposal whether it has been received by the Secondary Education Department.
Yes, madam.
Received
Today they have received.
today.
Today.
And today, the Director of Secondary Education, Hassan Kailipara, has received the aforementioned proposal. And Mr. Sharma submits that it may take 2 weeks' time, and he prays for listening the matter after 2 weeks. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that this is a place the matter on 28 July. 23rd July. 23rd July, as parted.
Lordship, item number 10. Lordship's order dated 18/6 may kindly be perused. Lordship, Finance Department was directed to apprise this honorable.
Department has accorded the concurrence of one post of tutor to accommodate Abdul Gupta.
Lordship, on last occasion, Lordship, there is a query from the Finance Department. Serial number 4, from when the post is to be created to accommodate Sri Abdul Gopur as tutor, Lordship. And your Lordship was pleased to hold that on last occasion.
No, have you linked the letter?
Lordship.
That letter he has produced today?
No.
Mr. Sharma furnished a copy.
Yes, I will find.
Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. U. Sharma, learned standing counsel for the Secondary Education Department. Mr. Soliha, you are also party here?
Yes.
No, Lord.
No, not party, but your Lordship directed.
Lordship, we have given a.
And also heard Mr. A. Soliha, learned standing counsel for the Finance Department.
Yeah.
During the course of hearing, Mr. Sharma has produced a letter written by the Deputy Secretary to the Governor of Assam, addressing the standing seniors and council Secretary Education Department, to the effect that one post of tutor to accommodate the petitioner, namely Abdul Gopur, in Gandhi
উচ্চ
Ussa
মাধ্যমিক
Ussa Madhyamik Vidyalaya Dhuguri is created. That finance department has already accorded its concurrence to a creation of one post of tutor to accommodate Abdul Ghaffur in Gandhi Ussa Madhyamik Vidyalaya Dhuguri district. And the matter is being attended and will be conveyed to the Director of Secondary Education shortly. So, Mr. Sharma, since when the post will be created?
Here it is not mentioned, my
Lordship, it should be 1/1/2021.
director will verify, my lord, and thereafter, this date will be mentioned.
That's on last occasion, your lordship was pleased to instruct them that I have already annexed a similar order, item number 9, lordship. Because both of them, there was some mistake in their part, in the spelling of the name. Instead of Abdul Gofur, it was written Abdul Tofur. And instead of Umar
Where
Ali
is that
Sheikh,
order?
lordship, we have annexed the order, similar order, lordship, that page 63. And relevant portion will lordship will get page 70, lordship. As para number 19, lordship. The service of the petitioner shall be so provincialized with retrospective effect from 1/2/2021, when the other teachers in the said school were so provincialized. Lordship, it was later clarified that it's 1/1/2021 in the miss case. Both of them are similarly situated.
Well, here only concurrent is made on from the finance department on the 24/6/2025, man. So thereafter it is sent to the now it will send to the director, my lord. Director will verify and fix.
No, concurrence was given, that's all right, but
for creation of
post will be created with effect from which date?
Yes, Lord. Yes,
in the endorsement as the petition will be entitled for benefit of utilizing
1/2/21.
1/1/2021 1/20.
Okay, all right then.
Then that is maybe recorded, Lord. Okay, that may be.
So if it is already there, there is
Yes, there
no requirement for making any observation in the order.
Let me kindly record, Lordship. Because the communication is there, Lordship, and I do not have that.
It is in the official note.
Lordship.
We'll see. You furnish a copy to him.
Lordship.
Accordingly, it is provided that this is a list the matter as further immediately after reopening of the vacation on 23rd July. The documents produced before the court shall be part of the record.
Item 8.
Okay.
Item 8 for hearing.
Will
authority
furnish.
May I please, Lordship.
So what order passed in criminal court has to do with the substantial question of law in the second appeal?
My lord, that is not discussed. The plaint was there. In the pleading, the pleading said there. That was not discussed.
Merely because the trial court has not discussed the same, in second appeal, we can consider it.
My lord, I'm not saying so that.
So you tell me,
My lord.
what substantial question of law is involved here?
My lord, here, my lord, substantial question of law involved herein regarding, my lord, and section 54 of Transfer of Property Act. The appellant before your lordship is the purchaser of a plot of land measuring 1.38 lesses of land to where he continuing his business, hardware business since 2000 and till today. He is in possession that particular 1.38 lesses of land. And in the year, and he was got a license for his business in 2002. And subsequently, the said land is purchased in 2000 on, my lord, 1/5/2000 without any registered deed, orally purchased at a very little consideration of rupees 90 only. That is why that was not registered. And subsequently, in the year 2015, the plaintiff respondent here claimed that he purchased the land measuring 17 lesses by registered deed. But in the schedule, my lord, in that plain, totally silent about the dag number, pattern number, also boundary. That is not proper, my lord, in the judgment, my lord. As because, my lord, how the land identified. That is, my lord, page 15, my lord, in my memo of appeal. The disputed land.
There is concurrent finding of both the courts below.
My lord, it is Munshi, my lord. Munshi Borpeta. And subsequently, that was decreed in favor of the plaintiff, and the present appellant approached the civil judge. That was rejected. And regarding that boundary and identity of the disputed land was not clear till today.
Trial court has decreed the suit.
Yes, ma'am.
In your favor.
Against my ma'am.
Against her.
Yes, my lord.
And the first appellate court has
Against me.
affirmed the same.
My lord.
Affirmed the same.
Yes, my lord.
This is against the concurrent finding.
My
of
lord.
fact.
My lord.
You see, from this, you have suggested 6 substantial question of law. Out of this 6 substantial question of law, where the question of law is involved, you suggested?
B, C, and D, my lord. Till today, I am in possession, my lord.
Pardon?
Till today, I am in possession, my lord.
You formulate the substantial question of law?
My lord, I am preparing separate sheet, my lord.
Third, Mr. M. Rahman, learned.
K.U. Ahmed. K.U. Ahmed.
K.U. Ahmed, learned counsel for the appellant. Place the matter on immediately after reopening. 21st July for further hearing. 21st, further hearing.
Made please, Lordship. With husband to dear. But I've gone through that judgment. In fact, the challenge was completely different. In fact, that judgment also has decided, my lord, the same point which I am relying by Brahmadev, my lord. Your lordship will kindly see paragraph 8 and 9 of that judgment, my lord. There were 2 points which came up for consideration before the honorable court, my lord. Para 8 and 9 first. The first and foremost contention of the learned counsel appearing for the appellant is that the predecessor of the respondent did not establish his independent right title interest in the property in question, and he was only pending like transferee, and therefore he cannot.
In the present case also, you are third party.
I'm a decree holder. I'm not a. In fact, that is decided in this court.
You
In
are
this,
decree holder.
Mala?
You are decree holder.
No, I'm a stranger because I'm a pattadar of that
That's
land.
why I'm telling you, you are the third party.
Yes. And this is decided, Mala. Here it is decided. Even a pending like transferor, if files an application under 97, it is incumbent upon the court to decide under 101. That, my lord, paragraph 26 is the ratio of this judgment, my lord. Paragraph 26. Therefore, my lord, find paragraph 26. Oh, sorry, paragraph 6, it is 16, referring to the judgment of 2022. The ratio, my lord, will find see. Therefore, just above paragraph 17.
Yes.
Therefore, once an application under Order 21 Rule 99 is filed, it is incumbent upon the trial court to consider all rival claims, including the right title interest of the parties under 21 Rule 101, which bars a separate suit by mandating the executing court to decide the dispute. Here, my lord, the question was a transferee pending light whether he has a locus to file an application under 99. Now that question has been answered by the Honorable Supreme Court that no, even if he files an application because he comes within the definition of stranger. That is decided in para 13, 14 and 15. That is discussed in para 13, 14 and 15. Married.
Not necessary.
My lord.
We'll say.
Yes. And my lord, the judgment which I relied on, my lord, Brahmadev's judgment, it has, my lord, it is absolutely on this point. My lord, the judgment which I
will say.
yes, my lord, I'll just point out the relevant one paragraph, my lord. Just one paragraph, your lordship will allow me. This is absolutely on this point, my lord. Paragraph 5. Just one paragraph, my lord, I'll just point out. Paragraph 5 of the judgment.
Yes.
Yes. The line starts from once such an obstructionist. My lord, it would be 8 line from the top.
Yes.
Once an obstructionist is on record, the executing court, it is difficult to appreciate how the executing court can tell such obstructionist that he must lose possession and then only his remedy to move an application under Order 21 Rule 99 and pray for restoration of possession. The High Court by the impugned order and judgment has taken their view that only remedy available to a stranger to a decree who claims any independent right or title or interest in the decretal property is to go by Order 21 Rule 99. This view of the High Court on the aforesaid statutory scheme is clearly unsustainable. It is easy to visualize that a stranger to a decree who claims an independent right, title, and interest in the decretal property can offer his resistance before getting actually dispossessed. He can equally hesitate his grievance and claim for adjudication of his independent right, title, and interest in the decretal property even after losing possession under Order 21 Rule 99. Order 21 Rule 97 deals with a stage which is prior to the execution of the decree for possession to the decree holder.
Okay, all right. We'll say.
And this was subsequently followed in 2020 in Ved Kumari Melo. That also I have given to your lordship.
Okay.
There, my lord, I am relying on paragraph 11, 12, and 13.
Okay, we'll say.
My lord. So, my lord, may I just humbly pray one thing, my lord? My intention is not to get the stay of the execution proceeding here, my lord. Apparently, my lord, the order where I have asked for a determination of my right has been deprived. So, if your lordship remanded back, my lord, at least my right should be determined.
We'll say.
Or else, my lord, the 1st of July is the date fixed for execution. The report of it.
Today we will pass the order.
My lord.
Item number.
I love bless.
Your Lordship. In this case, Lordship, already records are available before your Lordship and the service also complete.
Ready for hearing?
Yes, Lordship, ready for hearing.
2015.
Yes, in this case, what happened, Lordship, at the time of consideration of the injunction prayer, Lordship, an undertaking was given that they will not construct any further construction over the suit land, Lordship. Thereafter, on the basis of that, injunction petition was disposed of. So I am praying before your Lordship may fix after vacation a fixed date for final hearing of the entire matter, Lordship.
Okay. Or Ms. Arsoduri, learned counsel for the appellant, and Mr. Purkeso, learned counsel for the respondent. All the respondent?
No, I don't feel for it. 1 and 2.
1 and 2.
17 nearly,
1 and 2.
17.
1 and 2. It is submitted at the bar that service in this appeal has already been completed and the LCR has also been received. The matter is ready for hearing. Accordingly, it is provided that this is a lead the matter
On 19 August.
for hearing.
Can it be on 22nd July as they have already started some further construction,
No,
Lordship?
we are not going to make any construction, right? I can just ensure also.
July, already
Yes,
several
yes.
cases have been.
Then Lordship, that may be recorded today and thereafter fixed on the
That was
19th.
that in this case was.
But
already disposed of.
I have information, Lordship, they
Something
again
you
they
may
have,
You then you make an affidavit, file an affidavit. Order 5, order submission.
for that only, Lordship, I want a final
How
discussion.
can I be, my lord, compelled to make an affidavit?
Your Lordship will find there is an order, Lordship, that on the basis of that instruction, Lordship,
Fifth of August.
Lordship, I'm deeply obliged.
Item 12.
May it please your lordship. Here, as per the office note dated 17/6/25, two A, B, C, and 3, they have appeared by citing Wakalatnama. However, in regard to respondent 1, notices could not be served on them, on him, because this reason has been stated that he was out of station for a long time, and also usual process has returned with illegible signature. So under such circumstance, I will pay for taking steps to paper obligation. Because otherwise also, if I take steps again, then it will not serve the purpose. Paper publication on respondent 1.
What is to be done?
I'll take steps by taking the notice in a widely circulated newspaper.
Newspaper.
Yes. In terms of order.
Has got to learned counsel for the applicant and Mr.
K-Jen.
A. J.
K-Jen.
Learned counsel for the respondent number
2, 3, 4, and 5, Lord.
2, 3, 4, and 5. Office note dated 17/6/2025 indicates that notice issued to the respondent number 1 return answer with a report. Postal remarked that out of station.
Yes.
For a long time without any information. So return to sender. Mr. Dr. Learned counsel for the applicant submits that they may be permitted to effect service upon the respondent number 1 by substituted mode by paper publication. Where is accordingly allowed. The notice they publish in the in which newspaper?
In Assam Tribune.
In Assam Tribune. And in another paper.
In another Doinik Assam will do.
Doinik Assam. Fixing the date on?
Your lordship 1/9 on 1st
1/9.
of September.
1/9/2020. Is it a working day?
Late, Lordship.
1/9/2025.
No, there are some procedures which needs to be.
And recessal list the matter of. Okay.
Can it be taken in the month of August, Lord?
Or towards the end of August, because some procedure.
26 August. And recessal list the matter of. First of September.
Lordship, may I pray for listing of this matter with RSA 99 of 23, Lordship? It's a connected matter, Lordship.
Okay, recessal list the matter along with RSA number
99 of 23, Lordship.
99.
Your lordship, we'll take steps on 26/9. We'll show the date as 26 August.
Then we come today.
Obliged.
Item 13.
Lordship, item 13, after some time, Lordship, senior counsel is here, but he's on legs right now.
Lordship, in this case, the order of withdrawal has not been passed yet, where we have already filed the withdrawal petition due to the lack of the jurisdiction.
Lordship, after some time.
You
After
have
some
filed
time, Lordship.
withdrawal petition.
Yes, Lordship.
Where?
Lordship, that's I am not acquainted.
Okay, let us senior counsel.
Yes, Lordship.
Item 14.
None appears for the petitioner on call, leave the matter after petition.
Item 15.
Your Lordship, my lord, I filed an IA here for releasing the compensation amount as deposited, my lord, by the respondent in favor of claimant, my lord.
Any objection?
No objection, Lordship.
Heard Mr. N. Anand, Lord and Counsel for the applicant. This, and also heard Ms. N. Soikia, Lord and Counsel for the respondent, opposite party. This interlocutory application is prepared by the applicant for allowing to withdraw 50% of the awarded amount being deposited before the registry of this court. Pursuant to order. When it was deposited?
Where is the letter declared? Where is it?
Pursuant to order passed by this court in I civil number 1226 of 2023 by order dated order dated 11/10/3/2025. Ms. Soikia, learned counsel for the respondent opposite parties submits that she has no objection. Further taking note of the submission of learned counsel for both the parties, this court is inclined to allow this petition. The 50% of the awarded amount being deposited, that is rupees 16,52,600 being deposited before the registry of this court shall be allowed to. No, the petitioner may be allowed to withdraw the aforesaid amount from the registry of this court. In terms of this is closed.
Timing 13.
Lordship, the matter is ready regarding service and records. It may be fixed by here.
Which matter?
This matter. Item number 15.
In main appeal, you take down, heard Mr. Heard Ms. M. Soikia, learned counsel for the appellant, and also heard Mr. N. Anand, learned counsel for the respondent number 1 and 2. It's submitted at the bar that the LCR has already been received and service also completed, and as such, the matter may be listed for hearing. Accordingly, it is provided that this is the matter for hearing visual portion.
Of Lordship.
I realize.
Timing 13.
The IS for condonation of delay, and it has been submitted, they have filed an application for withdrawal.
Lordship on 29 January 2025. Withdrawal
They have
petition filed.
the challenge in the appeal is with regard to an interlocutory order that by which the encashment of the bank guarantee was restrained. Against that, we have filed preferred the appeal, but because of the lack of jurisdiction of the court, they have filed an application now for withdrawal of the main suit itself. So at this stage, I pray that delay may be condoned on the next day if the order is passed for withdrawal. In that case, the entire petition will become condonation part, 4 days delay. That may be
The withdrawal order is yet to be passed.
yet to be passed.
Yet to be passed.
So any objection in condoning the delay?
No,
You
Lordship.
have any objection in condoning the delay? Delay of
4 days.
4 days.
4 days. I have stated in paragraph 5.
Lord Mr. P.J. Sokia, learned counsel for the applicant. Senior counsel assisted by Ms. M. Nayola, learned counsel for the applicant, and also heard Ms.
S. Agarwal.
S. Agarwal, learned counsel for the respondent opposite party. This is interlocutory application under section 5 of the Litigation Act 1963 is referred by the applicant for continuation of delay of 4 days in filing the arbitration appeal before this court. Mr. Soikia, learned counsel for the applicant submits that. What is the ground?
My lord, in calculating the period of limitation, the council has inadvertently made some mistake, my lord.
Pardon?
Council have, my lord, in calculating the period of limitation, the council has made some mistake, my lord, inadvertently.
Submits that the learned engaged counsel of the applicant committed some mistake in calculating the period of limitation. And as such, the appeal could not be filed in time, and the delay is not intentional, and therefore it is contented to set it aside. Ms. Agarwal, learned counsel for the respondent opposite parties, such he has no objection. We are taking note of the submission of learned counsel for both the parties, and also considering the explanation forthcoming for the delay. This court is of the view that the same stands sufficiently explained, and accordingly the delay of 4 days in preparing the evidence on the in view of the order passed in I number 6. So now the residual proceed to register the appeal and list the same before this court as soon as practical.
Item 16.
There is an application for condonation of delay, my lord. Today, perhaps my lord, the IA for stay has come, but my lord, there is a pending application IA Civil 333 of 2025. That was for condonation of delay of 56 days.
Okay.
My lord, first the delay has to be condoned, my lord. Here the objection has been filed by the sole respondent, my lord.
File objection. Then I number 333 of 2025.
My lord.
Right?
My lord.
How many days?
56 days, my lord.
56 days. Yes, Mr. Sayola, any objection here?
Yes, my lord, we have filed the objection, my lord.
Objection.
Yeah, if your lordship see the petition, my lord, the official, my lord, that delay, my lord, correspondence are there, my lord. Our High Court has, my lord, passed the judgment, my lord, that this cannot be considered. Even 16-day delay has been rejected, my lord. I shall place two judgments of this honorable court, my lord.
What is the ground?
No, the basic ground, my lord, if my lord sees the, my lord, page 46, my lord, para 79. Page 46, para 79, my lord, this is the operative part of the judgment, my lord.
Para 46.
Para 79, page 46. If I may read, my lord, plaintiff, in order to justify the amount of his compensation, claimed adduced the evidence of PW3. PW3 is a registered valuer. In his evidence, he deposed that he received writ from this court, and after considering all papers submitted by the Exhibit 10 series, he submitted his report on 17/11/22. Exhibit 11 is the valuation report. Exhibit 11/1 to 11/13 are his signatures. However, during cross-examination, PW3 deposed that he didn't enter into the territory of Bangladesh for valuation, and his report contains information as received from the plaintiff company. He further deposed that he mentioned the value of plaintiff tea garden is not less than 8 lakhs per biga, but he didn't submit any document to prove the said value. Thus, under such circumstance, it is left upon the government to consider the valuation of land measuring 573 bigas, 2 kathas, and 3 chatak land, which is lying in Indo-Bangladesh border fencing towards Bangladesh side. Now, my lord, this is the judgment.
No, I am not asking about the judgment.
Yes, I am
asking
coming to it, my
about
lord.
the
Now, my lord, we'll
cause of
see.
delay.
Cause of delay. Cause of delay is, my lord, due to the official communication, my lord, because here the main respondents were border road organization, border security force, my lord. But the approval has to be taken from the Ministry of Home Affairs, Department of Border Management. My lord, page 58 is the office memorandum. Annexure
No,
5.
that's all right. You were to obtain approval from the Ministry of
Ministry of Home Affairs, Department of Border Management.
Home
In that,
Affairs.
in that,
But what prevents you from obtaining the approval within time?
my lord, it is only 60 days, 56 days delays, my lord. If my lord will
Maybe
see, we
it
were
may
supposed to
be-
file the appeal on or before 30/8/2024. And the process of correspondence, my lord, will take page 58. Because, my lord, the dispute here pertains to a land which has been transferred to Bangladesh, my lord, under the Indo-Bangladesh agreement. The dispute is pertaining to that, my lord. The lands were already transferred by way of an agreement between the government of India and under the statutory, my lord, by way of a notification. And now, though that land was been claimed before the, my lord, court below. So, my lord, at page 58 is the office memorandum whereby the Ministry of Home Affairs has decided.
No, the question is whether this is just ground or not to conduct.
Yes,
the
my lord,
plea of-
there are series, my lord. Had it been a delay of, my lord, maybe 100 days, only 56 days delays, my lord, I have.
Maybe, but you have to explain it.
Yes, all the, my lord, I have explained, my lord, each day delay I have explained, my lord, if my lord will see.
Where?
My lord, from paragraph 3 onwards, my lord. Paragraph 3 is the first stage, my lord. After the judgment and decree dated 30/5/2024, the legal opinion was sought from the concerned, my lord, advocate who dealt with the matter, and he gave a legal opinion on 7/6/24. My lord, the judgment was passed on 30/5/24. Thereafter, on 7/6/24, legal opinion was given by the government pleader. So, my lord, in the last paragraph of paragraph 3, we have stated 7 days time went in obtaining the legal opinion. Thereafter, the government of India on 11/6/24 forwarded the case along with the copy of the judgment and legal opinion obtained from the learned government pleader to the Director, Border Management, Ministry of External Affairs, with the copy to the government pleader for taking further necessary action. That further 5 days went in this. So, my lord, 7 days, 5 days, my lord, we have explained. Thereafter, that it is to state that the government of India, by letter dated 26/6/2024, reverted back the matter and refused to deal with the subject matter, stating that the matter has already been dealt by the Border Management 1 division of this ministry and requested to take appropriate action in the matter. So, well, there was some communication. So, matter was referred from the MHA FFR division to the Border Management division. So, the further 15 days went in the aforesaid communication. My lord, these communications are in chronological order with dates. My lord. Thereafter, my lord, paragraph 6, that it is to state that after the impinged judgment and decree.
Yes, Mr. Sahayala, what is your objection?
My objection, my lord, is official communication, my lord. This cannot be a ground, my lord. From one department to other, my lord, they are moving. They should know, my lord, from where they have to take the opening. So that is why, my lord, I have.
Mr. Sahayala, the principle is that some pragmatic approach has to be taken in the confirmation of delay, because if we
I
take
agree
a
to that, my lord, but
different view also,
yes, if
you will go to the Supreme Court.
Division bench judgment
then
also, my lord.
ultimately judgments are there.
Series of communications.
Ultimately, Supreme Court will allow it.
Your lordship, my lord.
Let us continue, let us hear it later on, right?
No.
Will you record your objection? Oh. We'll pass the order.
No. Lord, may I pay that, Lord, fixed date, because the execution is going there in Karimganj, my lord. That was I was reading.
First, we have to
Condone the
register the
delegates.
appeal.
Yes, my lord.
Unless the appeal is registered, we cannot pass any order.
It may be directed to be registered and.
Right to be
Ah,
registered
yes.
and a date may be fixed, my lord.
As soon as practical.
My lord.
That order.
Oblige.
17. Item 17.
May it please your lordship. In this case, we have filed one IA for early hearing, praying for early hearing, lordship.
Any objection?
We have no.
No objection.
Lordship.
Part is also already learned for the appellate. This application under section 151 of the Code of Civil Procedure is prepared by the applicant for early hearing of RSA number 329 of 2018. Mr.
Video lordship.
Learned counsel for the respondent submits that he has no objection. Accordingly, this interlocutor application stands allowed. This is the matter on
31/7 if possible, lordship.
19th August.
In case what happened, lordship, in this case inadvertently, we made a mention for listing of the case for hearing, lordship. Much earlier
the
than,
problem is
and
that
then,
madam,
lordship, we came to
already-
know that early hearing petition is pending, lordship.
already several.
Your
cases
lordship
are-
has already allowed our mention memo for 31/7.
Which date?
31/7. It was allowed for 31/7. Mention memo. Lordship. Deeply obliged, lordship.
Item 18.
May it please the lordship. We have to file this miscase lordship under 151. If there is a execution case is going on lordship, and we have received the notice of that execution case. Already there is a delay condonation petition is pending lordship. Second appeal is yet to register. My lordship limited prayer in this 151 petition is that till admission of the appeal lordship.
No.
Only one judgment of our high court I'm relying.
No.
Because otherwise lordship, if decree is executed, everything will.
Only after admission of RSA we will consider it.
But
Whether notice was served here.
we have taken steps. Report is not there. Office note is there. We have taken steps. Lordship, this is I rely on this judgment, lordship. If
No, we have not considered it earlier. When the proceeding was instituted,
lordship,
when that execution proceeding instituted,
it was instituted in 2019, but we have received this page 12, lordship. We have received the summon on 1625. Perhaps it was paid therein. We have annexed the notice of the execution case at page 12, 1625. Next date was 3625.
heard Mr. J. Victor learned counsel for the applicant. Office note dated 19/6/2025 indicates that notice issued to the respondent number 1 and 2. So the order was passed on 21st of April 2025. And you have taken step on 19/6/2025. Then you are praying for staying the execution without registering the RSA.
Lordship, after receipt of this notice on 16, lordship,
Yes.
we have.
If there was any urgency, why you have not taken the step on the very first day?
Step to the 19.
Office note dated
Yes, lordship,
19/6/2025 indicates
yes.
that
Yes, lordship, that is there, lordship.
step upon respondent number 1 and 2 have been taken only on 19/6/2025. In view of above, it is provided that residents shall list the matter immediately after reopening of the vacation, awaiting service report upon respondent number 1 and 2.
Item 19,
That lordship, can it be considered lordship?
Pardon,
On that, can it be considered this petition lordship?
you first serve the notice. Thereafter, we will take care of it.
Lordship.
My lord.
Obliged.
19.
Lordship, this case is listed first today. There is an IA for continuing delay for a period of 7 days, Lordship.
7 days.
7 days.
Heard, Mr.
Ekakoti, Lordship.
Learned counsel for the applicant. This interlocutor application under section 5 of the limitation act is prepared for condonation of delay of 7 days in filing MSC appeal against the judgment and order dated ever dated 27/1/2025. Passed in MSC case number 379 of 2021. So notice to the respondent opposite party by registered post, no, step be taken by registered post with AD and also by legal process within a week. This up to 4 weeks.
Obliged, Lordship.